We are live. The court is submitting all. Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Thursday, January 15th, 2024. The time is now 9:20. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this morning include Mr. Lopez, Ms. Noriega, Ms. Ramos, Ms. Cuellar, and Mr. Hernandez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, welcome. You're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez.
First in person, counsel Claude Goldsmith, page 5, number 12.
Fernando Espinosa Jr. versus Samantha Espinosa, cause number 2025 FLA 806C3. Court marks Mr. Goldsmith present in person. Mr. Espinosa, make your way to the front, pull up in front of a microphone, bring the microphone as close to your mouth as possible, and tell the court, are you Fernando Espinosa Jr.?
Yes, sir.
Welcome to court, Mr. Espinosa Jr. The court marks you present in person. The person to your left is your lawyer. Also present in person is Ms. Madeline Lopez Escoto. Welcome to court. Samantha Espinosa, are you present?
No, and not present online.
So noted. Ms. Escoto, Mr. Goldsmith?
Ms. Espinosa, Judge, and my client is not present. I am here on her behalf. We did attend mediation with Judge Hale, and we successfully mediated this case. I'm pleased to announce. We're just having some issues with regards to personal belongings in the house that Mr. Goldsmith and I are plowing through. We're asking for an entry date, Judge, but an entry date with a court setting, just in case we have to come back and deal with the issues with the belongings inside the house.
Mr. Goldsmith?
Your Honor, that's essentially the current state. We attended mediation on the 16th. That was successful. A few issues been raised as to division of personal property that we continue to work through, and we have been relying on the contract that is the mediated settlement agreement. So,
just so that the court is fully apprised, Mrs. Cotto, Mr. Goldsmith, is it the division of specific items or just the timing and coordination to retrieve certain items?
Specific items, Judge, that were just very general in the mediated settlement agreement, but one side believes that those things were included. And so I think we're down maybe to 2 or 3 things. So I'm hopeful that between now and the entry of date, we'll have it taken care of. And I emailed Mr. Goldsmith yesterday that my client went on Sunday. She'll go back this Sunday if Mr. Espinosa is available at 1 o'clock to pick up the rest of the items she was unable to.
That's correct, Your Honor. I'll discuss that with my client after the hearing.
Well, let me ask you both this, Mrs. Cotto, Mr. Goldsmith. You're set for final hearing, and you've already settled all the major issues before then, but you're scheduled for February the 12th. Would you like that date converted into an entry of judgment date?
That would be fine.
Is that at 9 or 1:30?
That is at 9 a.m. February 12th at 9 a.m. Mr. Espinosa, the court has received, reviewed, and considered your mediated settlement agreement. Congratulations for resolving your case. What the lawyers have just told the court and put it in plain English, there's been a lot of work, diligence, negotiations, and communication that has taken place, and all of the major issues in your case have been resolved. Now, the other things that are remaining, they're important, but they're not as big and substantial, which is good. You should be proud of the work both that your lawyer and opposing counsel have done. Mr. Espinosa will come back on February the 12th so that the court can review a final order and sign off on it to resolve and close out your case. Mr. Espinosa, do you have any questions for the court?
No.
I wish both you and Mrs. Espinosa well. Thank you all.
Thank you.
Judge. I'm gonna pop into the 406. I'll be right back.
Sure. Any other cases for Mr. Goldsmith?
No, Your Honor.
It's good to see you, Mr. Goldsmith. Have a great year.
Next in person, Counsel Olivero Canales, page 5, number 14.
Jesus Chung versus Miriam Lugo Chung, cause number 2025 FLA 1522C3. Good morning, Mr. Canales.
Good morning, Judge.
Court Martial present in person. Jesus Chung, Miriam Chung. Any person present?
They're not present, Your Honor. I submitted a motion for continuance. Both my client and the respondent reached out to me. They're trying to reconcile. So they're asking me for about 60 days, Your Honor.
Court has received, reviewed, and considered the request. It's both in writing and now stated on the record. That's a very good request. Good reason to give them some time. Ms. Flores, would you give us a setting in about 60 days, please?
March 31st at 2 p.m.
All right.
Page 8, number 21.
David Hernandez Romero versus Silvia Evelyn Lopez Deisner, cause number 2025 FLB 1526C3. Court marks Mr. Canales present in person. Mr. Romero, speak into the microphone and tell the court, are you David Hernandez Romero? Court has heard yes. Welcome to court, Mr. Romero. The court marks you present in person. The person to your left is your lawyer. Silvia Lopez Deisner, are you present? Court finds that respondent is not present in person, not present by video conference, and the court takes judicial notice that she was served with process on October the 30th, 2025. Mr. Canales.
Yes, sir. I think he prefers an interpreter.
This is a prove-up.
Yes, sir.
All right, we'll begin Spanish language interpretation now. Mr. Romero, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes,
You may lower your hand. Mr. Canales.
Yes. Is your name David Hernandez Romero?
yes,
And are you married to Sylvia Evelyn Lopez Disney?
yes,
Okay. Have you lived in the state of Texas for at least the last 6 months?
yes,
And have you lived in Webb County for at least the last 90 days?
yes,
Were you and your wife married on July 26, 1996?
yes,
And have you been separated since 2021?
yes,
And are there conflict of personalities between you and your wife where you can no longer live together as husband and wife?
no,
Well, Mr., is it correct that you can no longer live together as husband and wife?
no, we can't.
And is there any hope of you and your wife reconciling?
No,
Now, you have children, but they're all over the age of 18, is that correct?
yes,
Okay. And as far as property, Mr. Hernandez, you and your wife bought a property located 9310 Albany Drive, Unit 38, is that correct?
yes,
Okay. And who lives in the property?
my children and their mother.
Okay. And have you reached an agreement with your wife where you will convey your interests in the property to your 3 adult children?
Yes,
And are their names Benjamin David Hernandez, Evelyn Hernandez Lopez, and Biani Hernandez Lopez?
Yeah.
So as a result of this divorce, you're going to convey your interest in that property to your children, is that correct?
correct.
You understand you will have no interest in this property after this divorce is finalized?
Yes, I understand.
And as far as any personal property, are you asking the court to award you any personal property that you may have.
Can you please repeat the question?
As far as personal items, are you asking the court to award you whatever you have in your possession? And that your wife retains whatever personal item she has in her possession?
Yes,
Okay, and you told me that there was no debts resulting from this marriage? No.
No.
And do you still want the divorce, Mr. Hernandez?
yes.
Those are all the questions I have for Mr. Hernandez, Your Honor.
Just one question to you, Mr. Hernandez. You've made a request regarding the division of your property. Do you believe that that request represents a just and right division of your property?
Yes,
Is there anything else you would like to tell the court?
no,
Mr. Romero, in your case, cause number 2025 FLB 1526C3, the court at this time finds that it has jurisdiction over your case. The court finds that you entered into marriage with Ms. Sylvia Evelyn Lopez Deisner on the 26th day of July, 1996, but you stopped living together in 2021. The court finds that your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 3 children born in the marriage and they are now adults. And whether children were born in the marriage, were adopted, or are expected. The court finds that there is community property divide. The court finds that you have an agreement that your interest in the marital home will be conveyed equally to each of your 3 children. The court adopts and approves your agreement and finds that that is a just and right division. Any and all personal belongings in your possession are hereby awarded to you, and any and all belongings in Ms. Lopez Deisner's possession are hereby awarded to her. At this time, Mr. Romero, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and those orders are due to the court honor before.
January 26th at noon by submission.
Anything else on this case, Mr. Canales?
No, Your Honor, thank you.
Mr. Romero, I wish you well. Have a good day.
Maybe Exicio?
Good to see you, Mr. Canales. Happy 2026.
next in person, Counsel Guillermo Garcia, page 2, number 5.
Sergio Duran Albesa Duran, cause number 2024 FLB 1795C3. Court marks Mr. Garcia present in person. Mr. Duran, speak, pull up in front of a microphone, speak into it and tell the court, are you Sergio Duran?
Sí. Good morning, Your Honor. Javier Montemayor from Mr. Duran.
Mr. Montemayor, the court marks you present by video conference. One more time, are you Sergio Duran?
¿Es usted Sergio Durán?
Sí.
Yes,
Welcome to court. The court marks you present in person. As you can see from this screen, your lawyer is present and participating by video conference.
bienvenido al tribunal. Como usted puede ver por medio de su pantalla, su abogado nos está con nosotros por medio de videoconferencia.
Are you Albesa Duran?
Sí, ¿es usted Albesa Durán? Yes.
Ms. Duran, who is the person on your left?
Señora Durán, ¿quién es la persona a su izquierda?
Perdón,
¿Quién es la persona a su izquierda?
mi abogado.
My lawyer,
No, mi hija Paola.
my daughter Paola.
Mr. Garcia, is Ms. Paola a party to this case?
No, Your Honor, she's one of the adult children.
Right, I welcome you to court, Paola, but I'm gonna ask that you take a seat in the audience section. Mr. Garcia,
Your Honor, this is, I believe, Mr. Montemayor's motion to.
That is correct, Your Honor.
filed November 24th, right, Mr. Montemayor?
Your Honor, this is a motion for enforcement and clarification of the final decree of divorce. This court signed a decree on June the 9th. It was agreed to by all the parties. And in that decree, the parties agreed that within 90 days of the decree being signed, that Ms. Albesa Duran was going to pay Mr. Duran $85,000 for his interest in the homestead, which is located at 3406 San Salvador here in Laredo, Webb County. He would in turn sign over a warranty deed to Ms. Duran, waiving or giving her his interest in the property. We've come obviously a little more than 6 months now. It's been over 180 days, and there has been no payment by Ms. Duran to Mr. Duran, and so we're here now asking the court to want to clarify the decree, because the decree failed to include the language of the sale should she not comply. So we're asking the court to allow us to clarify the decree and allow us to get a realtor involved and sell the property by way of enforcement of this decree. So that's why we're here, and I don't believe that there is an objection to it. I think it's just a matter of getting a realtor involved. And in the interim, Ms. Duran can still come up with the money. We'll still be willing to sign that deed over.
Mr. Montemayor, before I ask for a, oh, I apologize.
Su señoría, estamos aquí para una moción para clarificación debido a que el decreto de divorcio se firmó el 9 de junio, en el cual todas las partes acordaron, de acuerdo al decreto, que en 90 días la señora le daría $85,000 a mi cliente por el interés de por parte del interés en cuanto a la propiedad 3406 San Salvador. Y mi cliente entonces firmaría el título para darle a ella el interés. Sin embargo, han pasado 6 meses o ya más de 180 días y ningún pago se ha hecho. Estamos aquí para clarificar, debido a que el decreto de divorcio no menciona que si es que no se hace pago, entonces la propiedad real se necesita vender debido al cumplimiento. Entonces estamos pidiendo que podamos ejercer una cláusula para poder vender el hogar y la gente de bienes raíces. No creo que haya alguna objeción. Sin embargo, a la señora también se le dará la oportunidad de que si puede obtener el dinero, lo puede hacer antes de la venta.
I should have said, Mr. Montemayor, and I'll do this now for the benefit of Mr. Garcia. We'll do this about 2 to 3 sentences at a time. Before I ask for a response from Mr. Garcia, Mr. Montemayor, to your knowledge, has any attempt to hire a realtor been made?
No, Your Honor. We've just been basically back and forth on status of payment and
Understood. Translation.
but no
please.
realtor.
Abogado Montemayor, ¿se ha hecho algún esfuerzo para contratar los servicios de un agente de bienes raíces? No, su señoría, solamente hemos estado hablando una y otra vez sobre el pago hacia mi cliente.
Mr. Garcia.
So Judge, to clarify, my client had been, from the time the decree was signed, trying to get the loan. And then some issues came up with at least one of her children. One of her daughters, the daughter that was here earlier, lives with her. The other daughter and her family had to come live with her as well.
Su señoría, para clarificar, mi cliente ha estado tratando de obtener el préstamo. Sin embargo, ha pasado ciertas cosas y una de ellas es que la hija que estaba presente ante el tribunal y la familia de ella han tenido que mudarse a casa con ella.
They're both adults, Judge. They're not minors, but regardless, she ran into issues having to help her children. And so she was not able to get the full financing that she needed. She's made several attempts. Various applications have been made to numerous financial institutions, as well as her employment. And she's made every attempt that she could to get the proceeds that were promised in the decree.
Su señoría, los hijos son adultos y ella ha encontrado, no ha podido financiar y ha hecho los esfuerzos para obtener el préstamo por medio de aplicaciones a instituciones bancarias y por medio de su empleo, y sin embargo no lo ha podido hacer también al ayudar a sus hijos.
So to clarify, Mr. Garcia, is Ms. Duran at this juncture claiming delay, difficulties, or impossibility?
We're not quite at the impossibility stage, Judge, but we're definitely having some issues, and some difficulties, obtaining the money that was promised in the decree. Mr. Montemayor and I have been discussing this over the past several months. We have been in contact with each other. We've attempted negotiations to try and settle it on our own. We've just the parties have been unable to agree to a set of terms that are
Ms.
acceptable.
Ms. Rodriguez.
Para clarificar, está su cliente diciendo que no puede o no puede con esto debido a dificultades o imposibilidad. Imposibilidad no, sus señores, sin embargo, dificultades sí en cuanto al dinero. El abogado Montemayor y yo hemos estado hablando sobre esto antes de venir ante el tribunal para llegar a una negociación y los términos. Sin embargo, ambas partes no están de acuerdo con los términos.
Well, it sounds like Mr. Montemayor is asking the court for a set of parameters going forward. If that's the case, what Mr. Garcia, is your client requesting, and what does she believe would be reasonable and necessary?
Well, Judge, she would like to continue to try and obtain the financing, given the amount of time that's passed. Ms. Duran has already been in contact with a realtor to attempt to sell the property. If the court would allow Ms. Duran to retain the realtor, and in the time that the property is being posted for sale, if she's able to obtain the financing, well, then we just take it off the market and pay according to the decree. If the sale comes through before we're able to get the financing, then I guess we would proceed forward with a sale, but
Ms. Rodriguez.
Abogado García, parece ser que el abogado Montemayor solamente quiere delinear parámetros, que es lo que está pidiendo su cliente, que es razonable y necesario. Su señoría, mi cliente está pidiendo que se obtenga un agente de bienes raíces y que se ponga, o que ella contrate los servicios de un agente de bienes raíces y que se ponga la propiedad en venta. Sin embargo, que se le permita continuar encontrando la posibilidad para financiar, y si es que se financia o lo puedes hacer ella, entonces se pondría la propiedad fuera del mercado para pagar lo que el decreto dicta.
So before I ask for a response from Mr. Montemayor, Mr. Garcia, how much time does your client believe at this juncture would be reasonable?
Your Honor, I think that's driven by the market. I mean, I don't know how long it would take for the property to be sold. I mean, she can sign it up with a realtor fairly quickly within the next couple of days, but at that point, once it gets sold, is a market-driven process.
Antes de que pida la respuesta por parte del abogado Montemayor, ¿cuánto tiempo está pidiendo su cliente y que ella encuentre razonable? Su señoría, eso depende del mercado. Puede ser que ella pueda contratar los servicios del agente de bienes raíces el día de mañana. Sin embargo, la venta de la propiedad puede tomar un poco de tiempo debido al mercado.
Mr. Montemayor.
Your Honor, we don't have a problem if she has a realtor. I don't think that's an issue. My client would have to sign on the listing agreement because he is part of the ownership. He's part of the title. So if we can have, maybe we can do this, as Mr. Garcia is suggesting. If we can just have a 45-day status on the sale, I think that would kind of keep us, I guess it doesn't fall through the cracks, I guess, in other words, and we'll be able to kind of feel where we're at. And again, if she comes up with the money in the interim, or we can work out some other type of an agreement, then it'll resolve itself as well.
Su señoría, no creo que mi cliente tenga algún problema en que la señora contrate los servicios de un agente de bienes raíces. Sin embargo, él tendría que firmar en el acuerdo debido a que es propietario aún de esa propiedad. Estaríamos pidiendo alrededor de 45 días para ver en qué estado o cómo están avanzando las cosas, si es que ella pudo obtener el dinero o si es que podemos llegar a algún otro tipo de acuerdo.
So why don't we do this, Mr. Garcia and Mr. Montemayor, because this court doesn't do statuses, because all the court can do at that juncture is hear complaints without giving resolutions.
Haremos lo siguiente, debido a que este tribunal no otorga audiencias de estatus, porque no podría darle a usted alguna solución y solamente estaría escuchando quejas.
So why doesn't the court order the sale of the property within 90 days of signing of the next order?
Entonces, ¿por qué no el tribunal ordena que la propiedad sea vendida dentro de los próximos 90 días después de que se firme la orden?
Failure to sell the home within those 90 days will effectuate a judgment for and against Mrs. Duran in the amount of $85,000 plus interest beginning on the date of the signing of the first decree, June 9th, 2025.
En la orden en la cual se diga que si no se vende la propiedad en los próximos 90 días, entonces se efectuará sentencia en contra de la señora Durán en un monto de $85,000 más los intereses intereses que se han acumulado a partir de la fecha de firma del decreto de divorcio del 9 de junio del 2025.
And what the court is doing here is just hitting reset on the process.
Y lo que el tribunal está haciendo es que está poniendo o reseteando el proceso.
And if Mr. Duran comes back and complains in an enforcement, that's what he's going to get in a judgment in any event.
Y si regresa el señor Durán y tiene una queja en cuanto al enforzamiento, entonces él está obteniendo lo mismo en cuanto a la sentencia.
Except that in this situation, you already know the outcome. Plus, you were given 90 days, I guess, free of any interest penalties.
Excepto que ya sabemos la solución final. Sin embargo, se le está otorgando 90 días sin penalidades a la señora.
This is your motion, Mr. Montemayor. Thoughts, comments, or objections?
No objections, Your Honor.
Mr. Garcia, same.
Your Honor, obviously, we'd like the court to consider not setting any interest charges against Ms. Duran. She's already having some financial difficulties. She's the only one caring for, they're adult children, Judge, and she's the only party between the two parties that's supporting the children that need the help. And so the burden is falling on her.
But these are adult children, are they not?
They are adult children. She's the one carrying the burden.
Sure. Translation, please.
¿Qué es lo que piensa, abogado Montemayor? No tenemos objeción, abogado García. Su señoría, solamente le pedimos al tribunal que considere no penalizar con los intereses, debido a que ella es la única persona que está cuidando de los hijos. Aunque sean adultos, ella es la persona que está cargando con ayudarles a ellos. Pero ellos ya son adultos, sí, su señoría, son adultos.
No, that's it.
So let me, I understand. So these are going to be the orders of the court, Mr. Montemayor. This is your motion. These are the orders that are due on or before.
January 26th at noon by submission.
So this order is going to supplement the decree.
Comprendo. Sin embargo, estas son las órdenes del tribunal y estas órdenes deberán de ser entregadas por el abogado Montemayor debido a que esta es su moción el día 26 de enero. Estas órdenes suplementan el decreto de divorcio.
Another property will sell in 90 days. After signing the decree,
Propiedad marital a venderse en 90 días después de la firma de esta orden o decreto.
sell within that time period will subject Mrs. Duran to interest
Que se vende esta propiedad dentro de esos 90 días o 90 días. Esto sujetará a la señora a los intereses.
subject to and without waiving any defenses.
Sin poner a un lado cualquier defensa.
Court is going to ask if you require that to leave the wheelchair and blank. There's something that the court has already here. The court is not convinced that Mrs. Duran has been able to secure the best and proper financing of the realtor.
Y le pidió al abogado contralor que deje en blanco el nombre de el agente de
connectivity
crédito
issues.
debido a que este tribunal considera o está convencido de que la primera ciudadana es el mejor agente de raíces o ayuda financiera.
Anything else in this case, Mr. Montemayor?
Objection, Your Honor. Your Honor, I'm having bad connectivity issues.
Calling the court heard no objections, Ms. Rodriguez.
No le puedo por parte del abogado Montemayor.
Mr. Garcia?
Nada por parte del abogado García.
Mr. Duran, keep in contact with your lawyers. I wish you both very well. Have a good day.
Con sus abogados, lo mejor. Buen día.
Any cases for Edith, counsel?
No, Your Honor.
Have a good day. Good to see you both.
Some person, counsel, de la Lord Matters, number 10.
Araceli Valdivia Martinez versus Raymond Lee Martinez, filing the 2025 SOA 223C3. Good morning, Ms. Maddox. Court Mr. Present in person, Mr. Santos, Rodolfo Santos, are you present?
Present, Your Honor.
Morning, Mr. Santos, Court Mr. Present, Mr. Participating by video conference. Araceli Martinez, Raymond Martinez. I'm going to ask you to unmute your device and tell the court, are you Araceli Martinez?
Yes, Your Honor.
Welcome to court, Ms. Martinez. The court must be present. You're participating by video conference, as you can see and hear from your device. Your lawyer is also present and participating by video conference. Raymond Lee Martinez, are you present? Martinez is not present in person by video conference. Ms. Maddox.
This is an agreement in this case, we settled, and I'm just, waiting on a proposed decision from Mr. Santos.
Mr. Santos?
That's correct, Your Honor. We're set for trial on the merits today, but we did recently submit to mediation with Judge Martinez, and after several attempts, we were able to resolve all issues. I anticipate that the decree should probably be before court and agreed to within 30 days, if Ms. Maddox would agree.
The last part, you asked for how much time?
Approximately 30 days, Your Honor, or less, depending on what the court's calendar looks like, of course.
Okay.
I know that time is already listed for sale.
We need to go through, so since this is the fifth setting, let's put this case is up for dismissal on February the 12th. We can keep that setting and also convert it to an empty date.
That's perfect for me.
That works for us.
This case is up for entry of judgment on February the 12th, and we're keeping that setting, but we're also including an entry of judgment February the 12th at 9 a.m. Ms. Martinez, do you have any questions for the court?
Hello?
Do you have any questions for the court?
I'm sorry, I can't hear you very well.
Do you have any questions?
Judge, I don't know if the court's having technical difficulties, but I'm also having issues with regard to the audio. It's coming in a little muffled. I don't know if that's what Ms. Martinez is experiencing.
Yeah. Yes.
I tell you what, Ms. Martinez, if you have any questions, keep in contact with your lawyer. I congratulate both you and Mr. Martinez and the lawyers for successful mediation. I'll call this case on February 12th. I wish both you and Ms. Martinez well. Have a good day.
Thank you, Judge.
Thank you.
Score number 11.
Lauren Darlene Castillo versus Ryan Augusto Castillo Yanes, filing the 2025 FRA 60123. Court marks Ms. Maddox present in person, Mrs. Corpo West present previously in person, heard the court on the record to be up for 406.
Just confirming, but we did file an agreed motion for continuance. The parties are attempting a reconciliation.
Just for the purposes of the record, Lauren Castillo Noe Yanes, any party present? Court finds no parties are present in person or by video conference. The court has received, reviewed, and considered a written and agreed to motion for continuance citing attempted or attempts to reconcile. The request is well taken and granted. Ms. Flores, would you give us a setting in 90 days?
April 28th at 2 p.m.
So ordered. Thank you.
Page 9, number 24.
Ivan Dominguez versus Abigail Alonso, cause number 2025 FLC 602C3. Court marks Ms. Maddox present in person. Mrs. Cotto present in the lobby of the court. Good morning, Ms. Garcia.
Good morning, Judge.
Court marks you present. You're participating by video conference. Ivan Dominguez, Abigail Dominguez, excuse me. Unmute your device and tell the court, are you Abigail Alonso? There's an unmute button at the bottom left of your screen, a microphone or a red button. Press that button, please. While she does so, tell the court, are you Ivan Dominguez?
Yes, sir.
Welcome to court, Mr. Dominguez. The court marks you present, participating by video conference. Your lawyer is making her way in. Are you Abigail Alonso?
Yes, Your Honor.
Court marks you present, participating by video conference. As you can see and hear from your device, your lawyer is present in person. Can you please ask Mrs. Cotto to come in?
Judge, I can make the announcement that we're conferring.
Never mind.
So she sent me an offer late, a revised offer late yesterday. I sent her a counter to that also late yesterday. I believe she's needs some time we need a little bit more time to confer. So if you could please put us on recall. I can represent to the court that most of the issues are resolved. I believe we have one or two minor pending issues.
Miss, yeah, very well taken, Miss Maddox. The pending minor issues, are any involving child conservatorship or child support issues?
One is child support.
Miss Garcia, just make yourself available should the parties need any help.
Of course.
All right. Mr. Dominguez, Miss Alonso, your lawyers are communicating, talking to each other and trying to get you to the finish line. So keep in contact with them. This will be the first contested matter on the court's docket this morning if there's no agreement. Mr. Dominguez, do you have any questions for the court at this time?
No, sir. I don't.
Ms. Alonso, do you have any questions for the court at this time? Ms. Alonso?
No.
All right. Stand by, please.
Page 10, number 27.
Carlos Eduardo Berra Senior, versus Blanca Perales, cause number 2025 FLI 1487C3. Court marks Ms. Maddox in person. Ms. Aldana is also present in person. Carlos Berra Blanca Perales. Are you Carlos Berra?
Yes, sir.
Welcome to court, Mr. Berra. The court marks you present. You're participating by video conference. Blanca Perales, are you present? Ms. Perales not present in person, not present by video conference. For the record, any person present on behalf of the Attorney General's office?
Elias Alcantar with the Office of the Attorney General on Zoom, Your Honor.
Welcome to court, Mr. Alcantar. Court marks you present and participating by video conference. Ms. Maddox, Ms. Aldana.
Yes, Your Honor, we have conferred and we're requesting additional time. So I'm sorry, we just conferred about it, requesting additional time so that we can actually talk about if we could come to an agreement for the temporary order.
Ms. Maddox?
That's correct, Judge.
When you say additional time, do you mean like days or do you mean some minutes this morning?
A new setting.
Understood. And it looks like there's a partial agreement via a partial temporary order?
Correct. We had a partial agreement and partial order issued by the visiting judge last month.
Right.
And we are aware of his rulings and we will continue to confer to set a more permanent temporary order.
Correct.
Sure.
And if
sure.
not a final order, we might be able to just hammer out a final order.
All right.
We'll confirm. Yes.
So I guess give us two settings, Ms. Flores. Give us a temporary orders hearing and then give us a final hearing thereafter.
Temporary orders, January the 28th at 9 a.m. And final hearing,
And
March 5th at 9 a.m.
Your Honor, could we have a final pretrial just in case we need it after the temporary order?
We're gonna be, I tell you what, convert the final hearing on March the 5th to a final pretrial. You can have your final hearing on that day if you're ready. If not, you can have it thereafter. Final hearing after March the 5th, please.
April 2nd at 9 a.m.
Thoughts, comments, or objections, Ms. Maddox?
Your Honor, I just didn't catch the time for the January 20th.
Temporary orders, January 28th at 9. Final pretrial, March 5th at 9. Final hearing, April 2nd at 9. Same question, Ms. Aldana, thoughts, comments, or objections?
No objection, Your Honor.
Same questions, Mr. Alcantar.
No questions, Your Honor.
Mr. Vera, the court has given you a scheduling order. Do you have any questions for the court?
No, Your Honor.
Between now and those dates, keep in contact with your lawyer. I wish you well. I wish both you and Ms. Perales well.
Thank you.
Thank you.
That's
Any other
all for
cases?
Council Maddox, just the one on recall.
Yes, thank you.
Next in person, Council Nathan 2, page 2, number 4.
Ashley Anali Martinez versus James Castañeda, cause number 2024 FLA 1863C3. Court marks Mr. Chu present in person. Welcome to court.
Good morning, Judge Nathan Chu present for Mr. James Casimir.
Yes, sir. Court marks you present. Ruben Arce, Julio Garcia Jr. Any other lawyers present? Court finds no other lawyers are present. I'm going to ask that you step right in front of a microphone, put it as close to your mouth as possible, and tell the court, are you Ashley Anali Martinez? Court has heard yes. Welcome to court, Ms. Martinez. Court marks you present in person. James Castañeda, are you present?
He's present, Judge. He was just outside.
Mr. Arce is in another court. He said that he had notified the court.
If he did, it wasn't in writing. Step up into the microphone, pull it as close to your mouth as possible, and tell the court, are you James Castañeda?
Yes, Your Honor.
Welcome to court, Mr. Castañeda. The court marks you present in person. The person to your right is your lawyer, Mr. Chu.
Judge, we do have an agreement. If you can recall us, so I can wait for Mr. Arce, Judge.
This is an agreement as to the final hearing?
The final hearing, Judge, all terms. Well, except for one term, which we'll put into the final order, but
Is the term related to marital property or to child issues?
it's an offset in child support. So
I
we
under-
just need it's just the numbers, like her wage and his wage, and then we'll get the offset amount.
Right, I'm going to place this case as a second contested case on the court's docket. But Ms. Martinez and Mr. Castaneda, what this tells the court, there's been a lot of talk, communication, negotiations, a lot of work that has gone into this case before coming to court. So you're almost at the finish line. We'll get you there today. Stand by.
Page 4, number 9.
Marcela Salas versus Hugo Salas, cause number 2025 FLA 100C3.
Good morning, Judge Nathan Chu present for Mr. Hugo Salas. He's
Court marks
present with me
you
in court.
present in person, speaking to the microphone and to the court. Are you Hugo Salas?
Yes, Your Honor.
Welcome to court, Mr. Salas. Court marks you present in person. Court marks Ms. Garcia present by video conference. Marcela Salas, are you present?
No, Judge, my client is not present today.
Why?
Because Mr. Chu and I have been conferring with regard to coming forward with an agreement, Judge. My client is dropping her request for the appointment of a guardian ad litem, and Mr. Chu and I are going to engage in informal settlement negotiations to try and bring this matter to a conclusion. So we discussed maybe setting this for final hearing within 45 days in the event the parties cannot come to an agreement. But given our communications, I'm confident we will.
That is correct, Judge.
All right. Ms. Flores, give us a setting in 45 days. Final hearing setting.
March 5th at 2 p.m.
I'm gonna put this on the record, Ms. Garcia and Mr. Chu. I am ordering all persons parties and lawyers present in person. I think this court had that order at the onset of this case, and then Mr. Salas wasn't coming to court, and then this court put it again in writing, and now Ms. Salas isn't present. And I know it's not Ms. Salas' request that initiated this, but this court always believes what's good for one is good for all. So just in case, for whatever reason, the negotiations are not fruitful, and I hope they are, but I think it's important that both Mrs. Salas and Mr. Salas be present. So whether you reach an agreement or not, make plans to move whatever's on your schedules and calendars, Mr. Salas, both you and Ms. Salas, to be present in court on March 5th at 2 p.m. And between now and then, keep in contact with your lawyer. He's continuing to negotiate, talk to, and communicate with Ms. Garcia to get you to the final finish line. Mr.
Yes,
Salas,
Judge, and I apologize. That was my mistake. I apologize to the court.
Mr. Salas, do you have any questions?
No, Your Honor.
All right, Ms. Garcia, anything else on this case?
No, sir.
Mr. Chu?
Judge, I'm confident that we will resolve this by March 5th. Thank you, Judge. Nothing
All right.
further.
I wish all persons well. Good luck to all.
Thank you, Judge.
Nothing further for Council Vanessa Garcia this morning.
Have a great day, Ms. Garcia.
Thank you, you too.
Next in person is Council Melissa Saldana, page 6, number 16.
Jose Luis Estrada versus Adriana Chavarria, cause number 2025 FLB 150C3. Court marks Ms. Saldana present in person. Mr. Knowlton present and participating by video conference. Are you Jose Luis Estrada?
Yes, sir.
Your Honor. and
Welcome
he's
to
present.
court,
Your
Mr.
Honor,
Estrada.
yes.
The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present also by video conference. Are you Adriana Chavarria?
Yes.
Welcome to court, Ms. Chavarria. The court marks you present. You're participating by video conference. As you can see from your device, your lawyer is present in court. Ms. Saldana, Mr. Knowlton, go ahead.
Yes, Your Honor. The parties have reached an agreement through a mediation with Judge Hale, and that MSA has been filed already, signed by all the parties, counsel, and Judge Hale. There was one issue pending that was not addressed in the mediation, and in fact, we had raised it at a previous hearing, and we were told that we could then address it at a later hearing. So that is that issue that we want to address today, and that's the attorney's fees. I am requesting attorney's fees in light of Mr. Estrada, Ms. Chavarria having mediated this, and then Mr. Estrada backing out and then not complying. In fact, he's not complying already with the MSA that has been filed. So we're asking for attorney's fees from Mr. Estrada to my client, Ms. Chavarria, in the amount of $4,725. I came up with that amount by going through my invoice and looking at the expenses that were incurred by my client up until the agreement that was made originally through and with the help of Mr. Ornelas, who used to represent Mr. Estrada. I subtracted that amount, and that's how I came up with $4,725 that we're requesting.
Well, I guess before we get a response or objection from Mr. Knowlton, Ms. Saldana, and it's not set for today, but I'm asking these questions to see if I can put Mr. Estrada and Ms. Chavarria in a good place today. Ms. Saldana, what are the areas of non-compliance with the MSA?
There are some bills that he was supposed to pay and he has not paid. He was supposed to make the home, like clean it up and make it habitable again. He has not complied with that. And I don't know if there are any other issues that Ms. Chavarria would like to address as far as his non-compliance.
The home, who currently is in possession, Ms. Saldana?
Mr. Estrada.
Respond, Mr. Knowlton.
Your Honor, I think that, first of all, if we're going to talk about non-compliance, that my client should probably have an opportunity to put on testimony as to these concerns. With regards to attorney fees, I feel like it's disingenuous for us to have entered into a mediated settlement agreement, have it signed and filed, and then afterwards ask for attorney fees. What happened originally is there was a document, and the court may remember, there was a document titled Mediated Settlement Agreement that was not mediated. It was more of a negotiated settlement conference, but it wasn't that because it didn't have the irrevocable language in it. So at best, it was a Rule 11 and it was revoked. There was a question, about when the court signed that Rule 11, which was the same day that we revoked that Rule 11. And Your Honor, you sent us to Judge Hale to mediate this. We went to Judge Hale, we mediated it, we were able to resolve it. And I know we can't talk about what happened at mediation, but the result of mediation, the signed and filed mediated settlement agreement, is different from the original Rule 11 agreement substantially in the amount of some student loan amounts that were the original issue of why we needed to revoke that Rule 11 agreement to begin with, Your Honor.
The settlement agreement.
I'm not talking about what's happening at settlement. I'm talking about the face of the documents that are on file with the court, Your Honor. So in any case, we were able to settle this. We got a different result, and I think these parties are ready to move forward. But to ask for attorney fees, when I think it's clear that we needed to go back and mediate this, we did mediate it in good faith. My client paid all the mediator fees for that, and then to ask for attorney fees after that, I don't feel like is appropriate today, Your Honor.
And since he did address some issues about the mediation, then I would have to respond that it was just very minor changes that were done. So it felt he was just dragging this on. He could have resolved it back then, or not made us think that he actually agreed to all these things and made my client incur $3,000 more than she needed to.
But if I understand correctly, the minor issues that may have been resolved before were actually in fact resolved at mediation.
It was it was changed. One thing was changed.
I don't think it was one minor issue. I think it was a student loan amount in the upwards of $90,000, right?
Again, you're going into the.
So,
No, I'm not.
Give me 1 second. So, and I guess then the premise of the fees requested at this juncture is due to the cost associated or the time associated because of the cost at mediation?
Correct.
Right. So look.
And preparing for it and having to argue the Rule 11 issue and all the other issues that came along with not having settled it back in June.
If memory serves, Your Honor, that original Rule 11 agreement titled Mediated Settlement Agreement, I believe was on Ms. Saldaña's letterhead, and it wasn't properly executed, and we needed to come to an agreement that was properly filed with the court as a mediated settlement agreement, and it is a substantial change. These student loan amounts, and I'm not going in mediation, this is on the face of these documents. They're quite different, Your Honor. It was a different result.
But it was acknowledged as a Rule 11.
Tell the folks, tell the court I guess it's your argument, Ms. Saldaña, the bill payments, is that in writing in the MSA? And what page?
The attorney's fees or the bill for the.
You told the court earlier that there was non-compliance with bill payments, including of the house, but I'm wondering the payment of the bills, where, if anywhere, is that located in the MSA? Page 5, fourth full paragraph. So I haven't placed anybody under oath yet, but Mr. Knowlton, based on Exhibit A, page 5, fourth full paragraph, to your knowledge, without knowing anything else, do you know if there's been compliance with these? There's specific dates with the payments of those bills.
I would need to confer with my client, or I would need to get his testimony.
All right. Yeah, understood.
May I?
Yes. Anything else, Ms. Saldaña?
Yes, Your Honor. As far as Mr. Knowlton, and I have worked well with Mr. Knowlton. However, I did give him notice of my client's complaints about Mr. Estrada not complying before this hearing. I emailed him and I asked him to talk to his client. So he should have conferred with him on this issue back then when I asked him to, and to show that he's at least trying to get his client to comply. And that wasn't done. Additionally, there was this dog with clips, and it's also in the MSA. My client was supposed to be awarded that dog. That dog is missing. He claims that he gave the dog to a family member. We can't find that dog. I mean, he's been.
Here's what the court's going to do. And you know, this court, and I'm sure many courts have faced this very similar issue. So here's the thing. Many claims, sometimes even including attorney's fees, are extinguished at the time of entering MSAs. I mean, you could save and accept it and reserve it for final. The thing is, the whole point of reaching that agreement is that you're fully done. Before I fully render, anything else you want to put on the record, Ms. Aldana?
No, Your Honor, just that my attorney's fees that we're requesting, that it was addressed at the previous hearing,
Yeah.
and we're just requesting that right now.
All right. So based on the information based on all of the information in the record at this juncture, the court must respectfully deny those fees. However, this is what you can put in your order. Ms. Saldana, given your knowledge, experience, and expertise, how much do you believe is a reasonable hourly rate for lawyers in this jurisdiction?
I'm sorry, I didn't hear the last part. Reasonable hourly fee for,
Hourly lawyer rate for attorneys in this jurisdiction.
$350.
Do you have any response or objection or controverting information or belief, Mr. Knowlton?
I do not have controverting information on that, Your Honor.
All right, so let's do this. In your final decree of divorce, since you have stipulated to this amount, if there is any non-compliance, it's going to be the subject of a motion for enforcement. Should that happen, then attorney's fees once again come alive, and you can forego any argument as to what each person has to prove up as reasonable and necessary. So you can each and both advise your clients that any non-compliance will be chargeable to the other side, provable in court at the rate of $350 per hour. Objections to this ruling, Ms. Saldana?
No, Your Honor.
Mr. Knowlton?
No, Your Honor.
All right. The court will set this for orders due on
January 26th at noon by submission.
all right.
Mhm.
So
And
go ahead,
who's
Mr.
drafting, Your Honor?
Yes, sir. Go ahead.
Who's drafting these orders?
I can draft it, Your Honor.
Okay, Your Honor.
As you all wish, by agreement, Ms. Aldana will prepare before the 26th, circulate it to Mr. Knowlton. You should have sufficient time to suggest any edits, modifications. Mr. Estrada, Ms. Chavarria, this should conclude your case, but what the court has done here is basically gotten the lawyers to agree on how best to short circuit this. Should Mr. Estrada fail to comply, should Ms. Chavarria fail to comply, you're going to be liable to the other side at the rate of $350 an hour. All right. So do everything possible to
Judge,
execute your agreement. Any questions, Mr. Estrada?
yes, sir. Judge, I need help with, there's one of our sons is still residing there. I need help getting him out. And I also need her to come and decide what she's going to take or not, so I can clean the house and get it out.
Well,
That's the situation there. As far as the bills that I need to pay, I actually need the divorce decree for them to switch it to my name so I can pay it.
Talk to your lawyer. I mean, so I'm going to honor your agreement with Ms. Chavarria, but it sounds like if there's an adult child present in the home, it sounds like it's a subject of another matter, probably before just of the peace, without knowing anything else. There may be different things going on, but talk to your lawyer. He can give you the best advice on how to land
Get
this
him out.
All right.
Thank
Ms.
you, Your
Chavarria,
Honor.
do you have any questions for the court?
No.
All right. Mr. Estrada, Ms. Chavarria, I wish you both very well. You're excused. Any other cases,
Thanks,
for Mr.
Judge.
Knowlton or Ms. Aldana?
None for Council Knowlton. Council Saldana, page 7, number
Have a
18.
good day, Mr. Knowlton.
Thank you, Judge, and Ms. Saldana, thank you for your courtesies also.
Thank
Have a
you.
good day, Judge.
You too.
This is, you said 718? This is Maria Angeles Garza versus Jaime Arturo Garza, cause number 2025 FLB 1225C3. Court marks Ms. Aldana present in person. Attorney Andy Reyes, are you present? Court finds counsel Reyes not present in person, not present by video conference. Parties. Maria Angeles Garza, Jaime Arturo Garza, are the parties present? Mr. Garza, I'm going to ask that you unmute your device and you start your video.
Señor Garza, Jaime Garza, active su micrófono y su video.
Court finds that there is a device present with that name, but the court cannot definitively ascertain if that is or is not Jaime.
Jaime
Are you
Garza
Jaime
present.
Garza?
Yeah.
Sorry for that.
Not a problem. Are you Jaime Garza?
Yes, I am.
Welcome to court, Mr. Garza. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present, but she's in person. Ms. Aldana.
Yes, Your Honor. In this case, Mr. Reyes brought it to my attention that I have previously met and conferred with Mr. Garza's current wife. That was several months before we met with Mr. Garza and didn't realize that there was a conflict. And so I'm gonna have to agree with his motion to disqualify and not be able to represent Mr. Garza. What is pending is discovery. And we were working on it, but since we've been asked to withdraw due to the conflict and his client's not waiving that conflict, then I don't think that we can give Mr. Garza the discovery that we've already prepared because of the conflict and it's still pending. So basically, with the court's guidance, I would just withdraw and allow him to retain new counsel to continue with that discovery.
Mr. Garza, it becomes necessary for rules, procedures, and ethical purposes for your lawyer to excuse herself from this case. You continue to have the right to hire any lawyer of your choosing that doesn't have a conflict with this case. Mr. Garza, how much time do you need to look for a lawyer and hire a lawyer if that's your choice?
Well, I just learned about this yesterday, and I asked Ms. Aldana to help me find a suitable lawyer. So I'm just in the process. I don't know how long it's going to take me. I guess a week, something like that, and then another week to confer with him and come out with what is going to be the path and all that. So I'm new to this thing, so.
Your Honor, could I request for him 45 days?
So
he can, we are gonna return all his money. I think we've already started that so that he can be able to pay someone new. But if
so
he needs some time.
the court, for all the reasons stated, or the information on the record, the court grants the motion to disqualify. Those are the orders of the court. The orders are due honor before.
January 26th at noon by submission.
I'm going to convert the final hearing date to a final pretrial date on February 24th at 2 p.m. And then we'll come back for a final hearing on
March 5th at 2 p.m.
Mr. Garza. What is your email address?
Jaime Arturo Garza at yahoo.com.
So.
I know how to spell it, but we need to make sure that it is clear on the record. So spell your email address for us, please.
Yes, Juliet Alpha India Mike Echo Alpha Romeo Tango. What is that? Arturo. Romeo ROGARCA. It's Golf Alpha Romeo Zebra Alpha at yahoo.com.
All right. Be on the lookout in your email. If the court needs to send you any information or any notices, it'll go to that email address. So we're coming back for final pretrial hearing on February the 24th. Please make sure to look for a lawyer and hire a lawyer if you choose to do so well before February 24th, so that that person is fully prepared and can represent you well. Do you have any questions for the court, Mr. Garza?
No, sir.
All right,
Yes,
I wish you well. We'll see you on the February the 24th. Good luck.
thank you.
Thank you,
Thank you, Ms. Aldaña.
Sir.
Jorge Perez Jr. versus Norma Hernandez Perez, cause number 2025 FLB 1235C3. Court marks Ms. Aldana present in person. Juan Garcia, are you present?
Present, Your Honor. Good morning.
Good morning, Mr. Garcia. Court marks you present. You're participating by video conference. The parties, Jorge Perez Jr., Norma Hernandez Perez. Are you present?
Yes.
Are you Norma Perez?
Yes.
Welcome to court, Ms. Perez. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present in person. Jorge Perez Jr., are you present? Court finds Mr. Perez not present in person, not present by video conference. Mr. Garcia, Ms. Aldana, go ahead.
Yes, Your Honor, we have conferred and we had already started the discovery process, and that's continuing. We also discussed a request for mediation with Associate Judge Leticia Martinez. I did submit that yesterday, an agreed motion for mediation. And so we're asking for a reset of the final pretrial so that we can continue getting the discovery, getting prepared for mediation if the court approves, and ideally getting it resolved before having a hearing.
Mr. Garcia.
Yes, Your Honor, that's correct.
Well, a couple of things, Mr. Garcia and Ms. Aldana. I'm not going to approve any mediations with Associate Judge Martinez at this juncture. I think it's not fair, right, or just to encumber her schedule as she's taking care of things for the court, hearings, and now she's involved in a race. So all that said, I will grant the request if you can agree to a mediator. We can appoint Senior Judge Hale, or you can just forego the request as you wish.
Your Honor, could we confer on a mediator, because Judge Hall is excellent. However, he is expensive, and our clients might have some financial
Sure.
concerns.
Would you like me to place the case on recall?
Mr. Garcia?
Yeah, I agree, Your Honor. We could maybe have it continue so we can finish the discovery, and then we can see if we can confer with another mediator, Your Honor. Because I think my client will also have problems paying for Judge Hale.
Yeah.
I think he's requesting another date.
Well, you're set for final hearing on February the 12th. That's about a month away.
We could do that date, Your Honor, and then if for some reason we still need a mediator, we could I don't know, we can submit a motion, Your Honor.
See, I'd rather you tell me now. So let me give you all some time to confer, because what I don't, y'all know this, I don't want y'all to come to court and then pop a setting because you need a mediation. So just request it now and agree to it now, or just forego the request altogether. I don't want any uncertainties on the dates of the final hearings. And that, quite frankly, is a benefit to your clients.
Also requesting a reset of the final pretrial is that we could get a ruling on that.
All right. All right, the court has signed the order. I've omitted agreed since it's not agreed to, at least the person isn't. The court hereby appoints Mr. Julio Garcia as the mediator in this case. We're going to convert that final hearing on February the 12th. And this should, the date of the mediation should be set within 7 days. And Mr. Garcia is present. Ms. Salania, confer with Mr. Garcia, get some dates, share those with Mr. Juan Garcia. I'm going to convert the final hearing date, February 12th, to a final pretrial hearing. The court wants to hear if there's any discovery disputes on that day, whether you have mediated already with Mr. Garcia, Mr. Julio Garcia, or whether any attempts have been made and there is a date already in place. And then we'll come back for a final hearing after February the 12th on
March 31st at 2 p.m.
thoughts, comments, questions, or objections, Mr. Juan Garcia.
No, Your Honor.
Same questions, Ms. Alanya,
And no objections except February 12th at what time?
at 9 a.m.
Thank you, Your Honor. I don't have any questions.
All right, Ms. Bettis, keep in contact with your lawyer. She's going to continue representing you and attending mediation with you. You have any questions for the court, Ms. Bettis?
No, sir.
Good luck to you.
Thank you.
Case line number 26.
Rebecca Isabel Cruz versus Humberto Magallanes, filed number 2025 SLE 1326C3, Court marks Ms. Alanya, present in person, Mr. Santos, present and participating by video conference. Rebecca Cruz, Humberto Magallanes, are you present? Stand to the right of your lawyer, Humberto Magallanes. Court of Yes. Welcome to court, Mr. Magallanes. Court, Mr. President, in person, you're standing to the left of your lawyer, sitting to the right, please on your left. Rebecca Cruz, are you present? Court finds Ms. Cruz not present in person, not present by video conference. Ms. Alanya, Mr. Santos.
Your Honor, to trial in this matter this evening, and I don't think there are any pending matters. We do have a current trial setting of February 12th at 9 a.m. We're ready to go.
Alanya
That's clear.
finds that there's no pending matters and this case is scheduled for February 12th at 9.
Your Honor, actually, one thing I just remembered. It is a termination, and if I recall, there should be a social or at least an item for the child, if I recall correctly, but I don't think that one has been requested or appointed. We did not file the motion or the petition.
Are you opposing the termination?
Your Honor, there's no motion filed. I understand that we could object, but I think that ultimately that an item is ultimately going to be appointed after all. I mean, in this case, so we have no objection.
I don't see how, and that's my point. You all are making arguments contrary to your client's positions, I think. This is your request, Mr. Santos?
No, it's not.
Ms. Saldana, this is your petition?
It's not, Your Honor.
Who's asking for the termination?
The mother, who is represented by Mr. Santos, is requesting the termination. My client.
Right, so when we get to the final hearing, and in fact, an attorney ad litem is required, and it's not requested by Mr. Santos, then the court can't grant his client's request, which is why it's surprising that Mr. Santos is saying don't do it. But
Well,
Ms.
Your Honor, I
Saldana,
believe
who
that.
doesn't want the termination, or I guess didn't file it, is making that request. So I guess I want clarification. Either we should appoint an attorney ad litem at this juncture just to get through that procedural hoop, or we shouldn't.
Your Honor, I believe that it's not necessary when the child's interests are adequately represented by the parent. And I believe that that's the case. This is a parent that's been solely in possession and control of the child since birth. Eventually, this is going to be an adoption as well, assuming that the termination is granted. Being that ultimately it probably will happen, like I said, we have no objection if the court wants to go ahead and appoint the ad litem. But our initial position and in our pleadings, we put that we're not requesting a guardian ad litem because we believe that the child's interests are being fairly represented by the mother.
Question that the court consider the appointment response, Ms. Alanya.
Yes, Your Honor. Again, mom filed the termination. My client did not object. However, I was concerned about a delay if an attorney ad litem wasn't was required and not appointed.
I certainly appreciate that, and that's exactly the court's point. I would rather, if one is needed, to do it now versus having to wait for delay. However, so the court on Thursday, on Tuesday, crossed a similar juncture, and the Office of the Attorney General objected to proceeding with the termination unless there was an adoption. The court heard, I believe, Ms. Saldana say that there's a possible adoption. True or not true, Mr. Santos?
Your Honor, there has been a father, a stepfather that's pretty much raised this child.
And is this a termination and adoption at this point, or solely a termination?
It's solely the termination. We want to focus on the termination, especially being that it's contested now, and then we'll move on to the adoption.
It's not contested, just to make it clear, it's not contested. I just don't want it to be delayed.
So then why don't we do this? Why doesn't the court schedule that February 12th setting as a final plea trial, and then schedule a final hearing thereafter to give Ms. Cruz some time to confer with Mr. Santos, because it's going to make the court's decision much clearer as to whether an attorney ad litem is necessary or not if the court hears testimony from some other person that is requesting to adopt this child. Certainly, that's very likely to be in the child's best interest, right? So crystallize that for the court. I'm not saying file or don't file. I'm saying take the time to talk to Ms. Cruz about that, and could she decide, I guess, her and her new spouse to do so, then we can do the whole process in one shot versus piecemeal over the course of many months.
I agree, Your Honor, and I appreciate that. I think that would make things a lot more efficient.
Okay. So let's come back on February the 12th at 9 for final pretrial hearing, and the court at that time will inquire if there's been sufficient time for Ms. Cruz to contemplate, consider, talk to her spouse, get the filings done. Ostensibly, those filings may already be in place, and then we'll come back for final hearing on
March 31st at 2 p.m.
thoughts, comments, questions, objections, Mr. Santos.
None, Your Honor.
Ms. Alani.
None. I just want to make sure, Mr. Santos, knows we are not objecting to the termination.
Understood. Understood, and that changes matters, and I think that we can work cooperatively to get this thing done.
Since there's a final decree of divorce, there's a good possibility the Attorney General's office may intervene. Should they choose to do so, the court has also just short-circuited any possible objections that they just by policy raise.
Right.
So, Mr. Magallanes, do you have any questions for the court? No. I wish both you and Ms. Cruz well. We'll see you soon. Good luck.
Thank you.
Have a good day. Thank you, Your Honor.
Any other cases for either counsel?
No, for Council Santos and Council Saldana.
Have a good day, Mr. Santos. Good to see you.
Council Silverio Martinez, 3, number 6.
Saldana doesn't believe she's on recall.
Page 3, number 6.
Melissa Cortez versus Brian Hale, cause number 2024 FLI 785C3. Good morning, Mr. Martinez. Good morning. Court marks present in person. Court marks Mr. Garcia present and participating by video conference. Court marks Mr. Elias Alcantar present and participating by video conference. He's here on behalf of the Attorney General's office. Are you Brian Hale?
Yes, sir.
Welcome to court, Mr. Hale. The court must be present. You're participating by video conference. As you can see from your device, your lawyer is present in court. Melissa Manette Cortez, are you present? Finds non-movement Cortez, not present in person, not present by video conference. Mr. Martinez, Mr. Garcia. Your Honor, this was a case that was brought in the master's court downstairs. And we filed the motion to transfer because there is a relinquishment termination issue that is agreed to by all the parties. However, the court did not have jurisdiction, obviously, to hear or to terminate, right? So we filed this motion to transfer. We're here asking the court to accept the transfer.
and set us up for final hearing, wherein, I believe there might be an issue. Mr. Garcia hasn't verified this, but it was mentioned at the last meeting that there might be an issue with some amount of child support that we can argue at the time.
Oh, you heard what happened on Tuesday, and you heard what just happened in the last case. This is your client's request, Mr. Martinez?
Well, I think it was a joint request to transfer because everyone's in agreement with the termination.
I apologize. The request to transfer, excuse me, the same thing. The request to terminate is whose request?
We filed it.
Right, so it's your request.
Right.
So do you know exactly now by policy what the Office of the Attorney General is going to do? Do you know if there is any possible pending or considered adoption?
Yes, Your Honor, there is.
Has one been filed?
No, it has not, but it was mentioned in court and I'm assuming it will be filed because Garcia is here to, I guess, verify that, but there was a mention of it that new spouse for Miss, forgot her name, is going to, ask for adoption.
So watch this, and the reason I do this is so that everybody's on the same page, case after case. Mr. Alcantar, there is a termination by policy. Will the Attorney General's office object unless there is an adoption?
Correct, Your Honor, unless there's an adoption.
Right. So, Mr. Garcia, knowing this and knowing that there is no there's termination, there's no pending adoption, has your client thought about, considered, contemplated, or discussed a possible adoption as well?
She has, Your Honor, but she hasn't given me an answer as to whether she wants to go for an adoption or not.
So let's do multiple things. First thing, there is a request to the clerk's office. Is there an order on the request to transfer?
Yes, Your Honor, the motion to transfer, the order was attached, Your Honor.
Negative.
Let me print it out, Your Honor, if you don't have it, Your Honor.
Order we had in, I know, I see it, I see it. No, you're right, you are right.
I have an issue on this.
Maybe that's why, but just to confirm, no objection on this request, Mr. Garcia, to transfer?
No objections, Your Honor.
Mr. Martinez, request. Any objection, Mr. Alcantar?
No, Your Honor.
I've made some minor modifications to the order granting. I just retitled it order granting motion. If you can transfer to like
another county per se. Uh, and then it requests it to transfer to a district court. So I've changed the language. It's further ordered that all proceedings related to the motion to terminate the parent-child relationship should be conducted before the sitting assigned or visiting judge of Webb County Court at Law 2. In the final paragraph, it is ordered that the clerk of the court shall transmit this matter to Webb County Court at Law 2 for further proceedings. So I've signed that order. Now, regarding this pending objection, you all know it's coming. So let me give you 2 dates. To be clear, the pending objection and the objection that you know is coming from the Attorney General's office should this solely be a termination. And the court may sustain or deny that, but at least you know that it is definitively coming. So let me give you 2 dates. Let me give you a final pre-trial and a final hearing date. Ms. Flores.
Yes, Your Honor, final pre-trial. February the 10th at 2 p.m. And final hearing March 31st at 2 p.m.
So what the court is doing with this, on February the 10th, at that final pre-trial hearing, if there's any procedural issues that the court needs to resolve, the court will do that at that time. The court is going to inquire on that date whether Ms. Cortez has had sufficient time to discuss and contemplate with her spouse a possible adoption, and then give the Attorney General some time between now and then to file or argue the objection, and then give Mr. Martinez and Mr. Garcia also time to contemplate that objection and respond to it adequately and appropriately. All right, Mr. Garcia, anything else on this case?
No, Your Honor.
Mr. Martinez?
Nothing else, Judge.
Mr. Alcantara?
No, Your Honor.
Mr. Hale, do you have any questions for the court? One more time?
No, sir.
Good luck to you and Ms. Cortez. You're excused.
Those are all the matters the council Martinez this morning. Council Garcia further down the line.
Good to see you, Ms. Martinez. Have a great year.
Next in person, Councilor Lee, number 8.
Eileen Hernandez versus Martin Ramiro Maldonado III, cause number 2024 FLI 1859C3, court marks Mr. Del Rio, present in person. Welcome to court. Good morning, Honor. Attorney Oscar Peña, are you present?
Yeah, it's zero.
Yes. Hello, can you hear me? Hello?
That loud and clear.
Hello?
Yeah.
Hello?
We can hear you loud and clear, but we cannot see you at all.
Hello, can you hear me?
Yeah.
Hello?
You, Eileen Hernandez.
Yes.
Welcome to court, Mr. Hernandez. Court must be present by video conference. You can hear your lawyer. Are you Martin Ramiro Maldonado III? Yes, Your Honor. Make sure the microphone is on. Yes, Your Honor. Welcome to court, Mr. Maldonado. The court must be present in person. The person to your left is your lawyer. And the court marks Mr. Elias Alcantar present by video conference. He's here on behalf of the Attorney General's office. Mr. Del Rio, go ahead.
Yes, if we're here for hearing on temporary orders, then we will need a hearing, Your Honor.
Mr. Peña.
That's
there
correct,
are,
It's correct, Your Honor. We need a hearing.
Mr. Peña, I just need to make sure that, so this case is now the third contested matter on the court's docket this morning. Mr. Peña, at the time that we go forward, just make sure that we can see and hear you appropriately.
Yes, Your Honor. Forgive me. Are you having difficulty hearing me, Your Honor?
I think you couldn't hear the court's questions earlier, but your video is still not on.
Oh, I understand. I'm sorry. I understand what you're saying. I will have that taken care of. No problem, Your Honor. Forgive me. I didn't realize that was happening. I'll take care of it.
Not a problem, Mr. Peña. I'm going to ask that you and Mr. Rodrigo talk to each other to see if you can narrow down the issues that are pending, and then the court will call this case as a third contested matter. Ms. Hernandez, Mr. Maldonado, stand by, please.
Thank you.
Next in person, Councilor Ruben Arce, page 10, number 28.
Vanessa Medina versus Aizar Coronado Medina Jr., talking to 2026 FLA 363. Good morning, Mr. Artem.
Good morning.
Court must be present in person. Tell the court, are you Vanessa Medina? Aren't you present in person, Ms. Medina? Welcome to court. The person on your right is your lawyer. Take the microphone, sir, and tell the court, are you Aizar Coronado Medina Jr.?
Yes, sir.
Welcome to court, Mr. Medina. The court must be present in person. Mr. Medina, I think you were recently served. Do you have a lawyer?
No, sir.
Are you going to hire a lawyer, or are you going to go forward without a lawyer?
I want to hire my lawyer.
Mr. Arce.
Yes, sir, we had filed a petition for divorce, there's also a TRO. I did speak to Mr. Medina this morning, that he did inform me that he was gonna hire counsel judge. So we're just asking to extend the TRO at this time and for another court date, Judge.
Okay. Mr. Medina, what is your email address?
It's gonna be Aizar, AIZAR dot C like car dot M like mom at hotmail.com.
Skip that, Ms. Porter.
Yes, Your Honor.
Your email, Mr. Medina, if the court needs to send you any other notices, information, requests, it's gonna be sent to that email address. Mr. Arce, until the time you hire a lawyer, may do the same thing. You understand this? You understand this?
Yeah.
What else it is? Ms. Flores, give us another TRO 7, please.
January the 28th at 9 a.m.
Any objection, Mr. Medina, to the court extending the temporary restraining order between now and until January the 28th?
Can you write it down? Because I don't want to, thank you so much. And I guess that's it. Just, can I ask you one question?
Yes, sir.
Please. Since I did not know anything about this until 2 days ago, and I found out that I have a restriction order. I'm not sure if my kids this weekend is the time that I supposed to see them. Because I was already divorced, so I don't know what's going on already. And I don't.
Were you previously divorced from Ms. Medina? Where was that divorce?
Okay.
Where did you get divorced?
Here in the waiting. I mean, Judge, there was a prior divorce, I don't know on this court, but the parties got together again. So this was back in 2021, but since that point, the parties have been residing together and living together for a while.
To your knowledge, Mr. Arce, has there been a signature on a final order?
There had been, yes, there's a divorce decree that had been submitted and signed.
Oh, so this is a common law.
Right, yes, ma'am.
Oh, I see.
But Your Honor, it never worked.
Well, so I mean, just so that you understand, Mr. Arce is agreeing with you. He said, yeah, there was another case, there was another divorce, but then you all got back together. And he believes, without knowing anything else, he believes that he's going to be able to prove that there then existed. You all created a common law marriage. So another divorce becomes necessary. So talk to a lawyer, a legal professional. No, I shouldn't say that. No, talk to a lawyer. Talk to someone with a law license from the state of Texas about what should happen and how best to represent you and present your case on January the 20th at 9. Do you have any other questions for the court?
No, sir. I'm sorry. Just about, I don't know, because I don't want to call her due to the restriction order. And I don't want to miss the chance to see my kids this weekend. So I don't know if it is my time or her time, because she's been changing that so many times.
Look over on this side at the calendar to confirm that what you're saying is true, and just take judicial notice of the
Including
of the calendar.
divorce papers right here. If you need them.
And just for quick information, Judge, and of course, we'll get that testimony from my client, but it was just until a week ago, Judge, that my client moved out of the home. So there had been no visitation prior because they were all residing in the same home.
Yeah, I guess, I mean, just as a matter of law, to resolve that issue, the divorce is final and the prove up of another, so that decree isn't extinguished until the common law could be proven up. So this weekend is the third weekend of the month. It looks like if there's a standard possession in the initial, and I guess sole at this time divorce decree, then Mr. Medina is correct. Mr. Arce,
I'll talk to my
I-
client
I-
about visitation for anything else.
without knowing anything else, right? The TRO, does it restrict Mr. Medina's visits at all?
The TRO judge, I don't believe it restricts visits. It's the standard TRO language where there shouldn't be any
Yeah,
harassing or threatening in any matter, Your Honor. But I'll talk to my client. I'm sure they can work something out as far as visitation goes.
right. Ms. Medina and Mr. Medina, you need to operate as though that final decree of divorce is live, well, valid, and enforceable, because it is, right? Until further orders of this court and other findings, if you present evidence and testimony, I could do something different, but that final decree of divorce has your possession schedule. The temporary orders in place are just meant to keep the peace. So be respectful with each other, be professional. Do not talk about this case with your children at any time. All right, if somebody asks me to interview them, I'm gonna have to do that, and then I'm gonna be able to figure out if there's any coaching or there's any information being provided to them. So don't talk to them about this case, but follow the scheduling order, the possession order with your children. Do you have any questions for the court, Ms. Medina? What is her no? Do you have any other questions, Mr. Medina?
I'm sorry, it's just a little bit nervous. I didn't understand quite well about if my weekend or her weekend with the kids.
There are no changes to your final decree of divorce. So that decree of divorce that has the court's signature, you follow that possession order until the court makes other orders.
Okay.
Okay. Any other questions?
No, sir.
Is that clear?
Yes, sir.
All right. I wish both you and Miss Medina well. More importantly, I wish your children all the best. Good luck.
Sir, you have a great day. Thank you.
Likewise to all.
Thank you, Judge.
Calling page 2, number,
Any other cases for Ms. Rodson?
yes, page 2, number 4.
Ashley Annalie Martinez versus James Castaneda, cause number 2024 FLA 1863C3. Court marks Mr. Arce present in person, Mr. Chu present in person. Mr. Garcia was present earlier. Ms. Martinez is present in person, and Mr. Castaneda is also present in person. All parties and lawyers are present. Mr. Arce, Mr. Chu.
Judge, we do have an agreement.
That's correct, Your Honor.
Go ahead.
May it please the court, Judge, we are here to modify the amended final divorce decree that was signed on April 14th of 2025. The agreement is as such, Judge, that the parties have agreed to a joint managed conservatorship. Ms. Ashley Martinez will be removed as the person with the primary right to designate the residence of the child. The parties have agreed that the child, that they will have split custody of the child, which transfer between the parties would be Monday to Monday, 6 p.m. Each week. The parties have agreed that the current child support of $1,080 that Mr. Castaneda was paying would be stopped. That was already stopped in the temp orders that was signed in July 22 of 2025, but we'll submit the order today to formally stop it, Judge. Medical insurance will be covered through Ms. Ashley Martinez. The parties will still be liable to pay 50-50 of any medical expenses for the child. The child shall remain in Webb County, but when during Ms. Ashley Martinez's time, she would be able to take the child to San Antonio for her medical treatment, Judge. And that is the agreement.
Just a few matters, Judge. I believe, Your Honor, that ac- according to my client, Judge, and we had spoken about it, that there should be an offset as to the child support. We're both to submit to each other, pay stub, Judge, and I believe that Mr. Chu's client earned a little more, Your Honor, so there'll be an offset as the child support. So although the initial amount will cease, there should be a new amount that will be calculated by both parties, Your Honor, so we can come up with that amount. And also, we had spoken about a reimbursement of medical support by his client, Judge. And we'll get them that information as far as how much my client is paying for medical support.
And then we'll get all that in at the entry due date, Judge.
Well, it looks like you're set for final hearing on February 24th. We can leave that on and also leave it on for entry, or also add on entry if you'd like.
No, we'd like to just get this done today, and then on the entry, we'll plug in the
I
offset
see.
amount.
And like an order due date.
Yes,
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 Your Honor.
yeah, that would be better.
Ms. Martinez, Mr. Castaneda, would you raise your right hands? That each of you solemnly swear or affirm that the testimony you will give in this call will be the truth, so help you God?
Thank you, Your Honor.
May lower your hands, so. Do you want to ask them or do you want me to ask?
I can ask.
Go ahead.
Mr. Castaneda, you heard what I read into the record. Are you in agreement with that? Yes. And you believe that it's in the best interest of your child? Yes. That's it.
Mr. Addison?
Yes, Your Honor. Ms. Martinez, you had heard what was read into the record, and she understands that the agreement that we had spoken about?
Yes.
And you believe that that agreement is in the best interest of the child, and that is your agreement? No other questions?
Mr. Castaneda, Ms. Martinez, in cause number 2024 FOA 1863C3, the court finds that it has exclusive continuing jurisdiction over the matters regarding your child or children in this case. I think both of you find yourself in a very good place in your lives because not only have you had good and diligent representation that has gotten you to this juncture, but without knowing the facts and circumstances of your case, I can adopt and approve your case and find that it is in your child or children's best interest, knowing that this court never grants split custody unless there's an agreement. So had there been a disagreement, one person would have had the child and the other person would have been paying child support. But you know your facts, circumstances, and situations and lives better than anybody else. So the court hereby adopts and approves your agreement, finds that it is in fact in their best interest. These are the orders of the court. And the court will order these orders due on
January 26th at noon by submission.
through the orders of the court. I've adopted and approved your agreement. Ms. Martinez, do you have any questions for the court?
Yeah.
Mr. Castaneda, do you have any questions?
No, Your Honor.
Put it up, say Junior Adlato. I don't have any objections. I spoke to both parties. They were able to work it out themselves. So I have no objection as to the agreement, obviously, that they entered into. I think that'd be in the best interest of the child.
The court appreciates your time and diligence. Thank you, Mr. Garcia.
And Judge, we'd like to thank Mr. Garcia as well, Judge. I know that he had spoken to both parties and assisted in getting this matter mediated.
On behalf of my client, we also like to thank Mr. Garcia for his service, Judge.
All will taken and noted. One more time, Ms. Martinez, do you have any questions? Mr. Castaneda, do you have any questions?
No, Your Honor.
I wish you both well. More importantly, I wish your families all the best. Good luck.
Thank you.
Thank you, Judge. That's all I have, man. Big
Good to see you. Have a great year.
Likewise.
Judge,
Thank you
that's all
both.
I have. Big see you.
Have a great year as well. Good to see you.
Thank you.
Julio Garcia, page 7, number 20.
Maria de Los Angeles Mireles versus Jerónimo Ibarra, cause number 2025 FLB 1514C3. Court marks Mr. Julio Garcia Jr. present in person. Luis Antonio Tony Figueroa, are you present? Court marks Mr. Figueroa not present in person, not present by video conference. Maria Mireles Jerónimo Ibarra, are the parties present? So noted, Mr. Garcia.
Yes, Your Honor. I spoke to Mr. Figueroa yesterday. We filed the Rule 11. We needed additional time to exchange discovery and see if we can try and reach an agreement on this matter, Judge. But I believe we can.
Court finds this is the first setting by policy of the court. The court will grant an additional sitting. How much time are you requesting?
We can have 45 days, Judge.
We'll take it. Ms. Flores.
March 5th at 9 a.m.
Any objections to that date?
No, Judge.
So ordered. Any other cases for Mr. Garcia?
No, Your Honor.
Always good to see you.
You
Have
too,
a great
Judge.
day.
Thank you very much. May I have your excuse?
Yes, sir. Thank you.
Encounter and council in person. Lopez Escoto, page 1, number 2.
This is Galinda de los Santos versus Eduardo de los Santos, cause number 2018 FLA 500C3. Court marks Mrs. Scotto present in person, Mr. Elias Alcantar present and participating by video conference. He's here on behalf of the Attorney General's office. Are you making an appearance on this case, Mr. Martinez King?
That is correct, Judge.
And you're making an appearance on behalf of Ms. de los Santos?
That's correct.
Court marks you present. You're participating by video conference. Galinda de los Santos, Eduardo de los Santos, are the parties present?
The vice for Ms. Caldina de los Santos.
Court marks that the vice president, all the parties are present. Ms. Escoto, Mr. King.
And Madeline Escoto for Mr. De Los Santos, Judge, he is not present. We were working with, and I don't know if Mr. Alcantar knows, we were working with Ms. Catherine Garcia on this case. She prepared the proposed credits for possession of Mr. De Los Santos and the male child. And then she also prepared the credits for the cohabitation credits between the parties. And she was going to just have to prove it up today. I don't know if Mr. Alcantar has her notes.
Your Honor, and this was obviously before Mr. King joined on. We did speak to Ms. De Los Santos. She did agree that there was some cohabitation back in February of last year until about September. And then there was some contested issues as to the 2018 date that was previously given in court. I do have some numbers today. I'm not sure what Mr. King's announcement is going to be, but I do have those.
So, Mr. King, have you had an opportunity to receive, review, consider, contemplate, and discuss those numbers with your client?
We have not received the numbers as of yet.
And I don't object, Judge, to having another short conference with Ms. Garcia or Ms. Alcantar so we can go over those numbers and those dates with Mr. King and come back and just hopefully by submission, submit an agreed order.
Mr. Alcantar, can you disclose whatever those, do you have that information available?
Yes, I think Mr. King dropped. So based on the numbers I had, there was possession credit from February until September, but back in August, or we did a temporary order modifying child support starting in August. So the days are going to be from February until July 31st. The total amount credited, including interest, would be $4,040.94. And this was on the agreed portion from when we spoke to Ms. Los Santos before she was represented.
The agreed to number was 4,400.
The agreed to dates.
I'm sorry, again?
The agreed to dates. I'm not sure if if Ms. Garcia, Ms. Catherine Garcia went over the numbers with Ms. De Los Santos.
I heard the dates, but I also heard a number.
Yes.
No.
So it was the days. Then based on those days, this is the number I came up with. But I'm just letting the court know that I didn't.
These are your numbers. What are your numbers?
Yes, $4,040.94, including interest.
40 with 90 cents. Is that what you said?
Yes.
94 cents. Was it 94 cents?
94. I'm sorry.
Right, Mr. King, before I release you, I'm going to ask that you talk to I'm going to place this case on recall. I'm going to ask that you talk to your client about these numbers. And the reason I do this, so one, ostensibly, you are entitled by policy of the court for additional time. I'm looking at the filing date of the petition to modify. That was back in July. By other policies of the court is going to grant more time. However, I need you to talk to your client about this before I release you, because the very next setting is going to be the final with a dismissal date. In other words, this court is looking to close this out as soon as possible.
And I also want to interject, Judge, there are cohabitation credits that Ms. Garcia went over with both parties, July 1st of 2018 to March 1st of 2023. And I don't know if he has those numbers.
We do not have those numbers, but if we can get them and if we can be placed on recall, I can go over it with Ms. De Los Santos.
We can,
Talk to each other about this and tell the court that you're already there and we can close this out, or tell the court that you're in a good position. And then tell the court how much time would be reasonable and necessary to come back for final hearing. I'll get a response or objection to that date, and then I'll give you that date. Thoughts, comments, questions, Mr. Alcantar?
yes, Your Honor, I could provide those numbers.
Mr. King?
No questions, Judge.
Mrs. Cotto?
No, Judge, I'll wait here until they conferred.
Page 2, number 3.
Mirta Saucedo versus Miguel Angel Saucedo, cause number 2023 FLA 694C3. Court marks Mrs. Cotto present in person. Mr. Peña, Oscar Peña, are you present?
I am present, Your Honor. Can you see me now? Can you see me?
Good to see you. Court marks you present, participating by video conference. Mirta Saucedo, Miguel Angel Saucedo, are the parties present?
My client is not present, Your Honor. We were here on entry of judgment and we just filed an agreed order. I think it was filed a few minutes ago.
That is correct, Judge Madeline Escoto for Mr. Salcedo, Judge. And this is just one of those cases that we were having issues with the actual language of the order, but we've come to an agreement, and so now it's been submitted, Judge.
The court has received and reviewed an order modifying spousal maintenance. It is agreed to by both parties, signed by both counsel. The court has signed off on it, tendering the original signed order to the clerk's office. That concludes this case. Any other cases for your counsel? And Mr. Peña's on recall. Yes.
Page 5, number 13.
Yes, Your Honor. Okay, I'll be waiting around, Your Honor. Thank you.
Thank you. Eduardo Aguero Jr. versus Yelitza Aguero, cause number 2025 FLA 1099C3. Court marks Mrs. Cotto present in person. Are you Yelitza Aguero?
Yes, Your Honor.
Welcome to court, Ms. Aguero. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Eduardo Aguero, are you present?
He is not present, Judge, and Madeline Escoto for Mr. Aguero.
Go ahead.
Judge, we attended mediation with Judge Hale. However, it was unsuccessful, notwithstanding a mediator's proposal that was sent by him. Mr. Castillo and I have been diligently exchanging revised mediator settlement proposal. I sent one to him last night. And I know that he has filed a motion for continuance. I'm not opposed to the same, since he has a vacation letter since November.
For today's setting.
Yes. So I looked at the exhibit that was attached. So I'm not gonna oppose. He's at a conference, Judge, and actually took my calls yesterday while at the conference. We're just gonna ask the court for preferential setting so that we can finalize this case.
Mr. Castillo?
Judge, that is correct, Judge. I do have the motion for continuance on file, Judge. I know I also have a motion for a guardian. I don't know if Madeline wants to take that up right now, or we can wait for later, Judge, but I know it's opposed, so I guess I'd rather discuss it right now and not lose any more time, Judge, either way.
Yeah, I don't know if that for today, Judge. And if it's not, I asked.
It is.
It is, okay. And so I have a quick response to that, Judge. I think that the court is a trier of fact based on the issue that has been raised. There is no need for a guardian ad litem. These are two minor children. The parties are in the process of a divorce. I think that once you hear the testimony as to what is in the best interest of the children, the court, with its experience and wisdom, will be able to make a determination as to what happens with these two people post them dating other people after this case has been finalized.
Judge,
And
go ahead.
they want a morality clause, Judge. That's what this case is about. And so, you know, I've already explained to Mr. Castillo, Judge, that the parties are getting a divorce. They're gonna live their lives the way they're gonna live their lives, hopefully making sure that what their actions are in the best interest of their children, but you know, it is what it is.
Mr. Castillo?
Just a quick response, Judge. It's our position that the children have already been put in an unstable and inappropriate situations, and I would like an ad litem to get down to the bottom of it. If it is, the ad litem would make the finding and make a recommendation, and if it isn't, it isn't, Judge. Well, my client will drop the issue.
So things I like about this case. Let's be positive here. So, Mr. Aguero attended mediation with counsel with Senior District Judge Hale. That shows effort, good faith, attendance, participation, all these things. Unfortunately, it was unsuccessful. Without telling the court what the arguments or issues were, y'all tell me, is this one of those situations where all but a few things are left, or all but a few things, and because of that, now the whole thing is back on the court's plate?
Not please tell the court that there's probably only two issues, one having to deal with the marital residence, and now this issue of this morality clause.
More or less,
It's my understanding has been agreed to.
more or less correct, Mr. Castillo?
More or less correct, Judge. I think we are eventually going to need a finding from the court as to the cause of the divorce, and then the judge can, I guess everything else will fall in place. That is for on the house issue, Judge. On the other issue is just the I don't think there's an issue as to visitation, Judge. The parties have been somewhat working alongside, but it's more of a our position is that there's been not just one, but several other adults brought into the picture and introduced to the kids, which we feel is not in their best interest.
So why don't we do this, folks? I understand the situation. So the House, I can't do anything about. Y'all either get to an agreement or don't, and put your evidence and testimony on, and I'll figure it out and give you a decision. The morality clause becomes a little bit more tricky, does it not? I know other courts have policies that they never order those, because then I've heard that then enforcement becomes an issue, and there's all these espionage or spying issues, right? At least that's what I hear in other courts. This court has granted them when and if necessary, if the appropriate evidence and testimony is put before the court. However, at this juncture, if there's an issue regarding custody, and it's very likely that somebody at some point is going to request that this court meet with the children in chambers. So why don't I just, and ostensibly, if the court appoints anybody at this juncture, I'm going to give you a date, that person is going to get appointed, and very likely say, I need more time. So why doesn't the court just give you a final hearing date at 2 p.m. on some date, and then ask that the child or children be brought to court for an interview in chambers? That way, I hear from them directly. Thoughts, comments, questions, Mrs. Corporal?
Glad the court has the espionage and stalking, because even Mr. Castillo's pleadings before the court have pictures where father is stalked, father is.
Well, so I don't know any of the facts. I'm just saying there's other courts that refuse to grant these things for reasons that are similar to what you're. I don't have a problem with it as long as the evidence and testimony supports it.
I think the problem is, I think, Mr. Castillo, you can correct me if I'm wrong. The children are both, there's one that's practically a toddler, maybe 3, correct, Mr. Castillo? And the other one is 8?
Yes, the other one is, I believe, is 8 or 9.
So I don't know If the court really wants to talk to an 8-year-old in chambers and further probably make her feel more uncomfortable in terms of the adjustments of the party's divorce, but that's something that the parties will have to think about before that final.
Well, so crystallize the argument, and I'm not saying one way or the other, whatever your thoughts, opinion, and objections are, because if the court grants the request for an ad litem now or in the future, that concern may be exacerbated. You know what I'm saying? So if the court, and it may happen or it may not, but if it does happen, then that person will have multiple points of contact with those children versus a one time with the court.
I'm okay with the court talking to the 8 or 9-year-old judge. I don't think the ad litem is necessary. The parties don't need the extra expense. It's just another way of delaying this case. The faster we finish it off, and I know that Mr. Castillo and I have gotten calls on weekends, in the evening hours, just with a lot of issues with this case. So the faster we give them a hearing date so that they can finalize and get a resolution, that will be in the best interest of these three children.
Thoughts, comments, questions, or objections, Mr. Castillo?
Judge, in lieu of an ad litem, if Your Honor will speak to the adult, to the not the adult, but the older child, there's no objection, Judge.
So let's do that. It'll save time, it'll save expense, and this attorney ad litem is going to act as a witness in any event, even if they find out of any other situations. Court will be able to ascertain whether the parties are coaching this child. The court will be able to ascertain if this child is in a relatively good developmental place, likes, dislikes, and all these things. All right, Ms. Flores, it's going to be a 2 p.m. setting, so the court can schedule a 1 p.m. interview. Give us the next available 2 p.m. In on or about 30 days.
It'll be February the 24th at 2 p.m.
Ms. Agüero, I'm going to tell you what Mr. Agüero will be told by his lawyer. Keep in contact with your lawyer between now and then. Don't talk to your children about this case. I'm going to be able to figure out by speaking to your older child in an age-appropriate manner what is going on, who's talking to them about this case, if anyone, and then I'm going to be able to make decisions based on their best interest. You understand all of this, Ms. Agüero?
Yes, Your Honor.
Do you have any questions for the court?
No, not at this time.
I wish both you, Mr. Agüero, well, but more importantly, wish your children all the best. We'll see you on February the 24th. Good luck.
Thank you.
Thank you, Judge. May I be excused, Judge.
It's good to see you, Mr. Castillo. Have a great year.
Thank you, Judge. Appreciate it.
Page 6, number 15.
Nate Hill versus Ashley Stewart, cause number 2025 FLA 1797C3. Court marks Mrs. Cotto present in person. Puneet Gill, Ashley Stewart, are you present?
They're not present, Judge, and Madeline Escoto for Ms. Hill. Judge, we submitted to the court a signed proposal with all of the terms in the best interest of the minor child and a temporary division of assets and debts. Pending the final court hearing, Mr. Stewart came to the office, signed with a picture ID, and the disclaimer language is in there that I was not his attorney and signed it freely and voluntarily. I'm going to ask the court that the court approve the same, and those will become the temporary orders.
Court has received, reviewed, and considered Rule 11. It is signed by petitioner's counsel and respondent. The court has signed off on it. It is approved. It is signed. These temporary orders are due in appropriate form to the court. Honor before.
January the 26th at noon by submission.
Ms. Flores, just take notice that respondents, thank you for doing this, by the way, Mrs. Cotto. The respondent's email is listed, so just make sure that that person is being copied on all filings,
That's right.
if not already. I don't know. All right.
Page 6, number 17.
Elizabeth Flores, Jorge Armando Flores, file number 2025 FLB 863C3. Court marks Mrs. Cotto present in person. Rebecca Ramos Gonzalez, are you present?
the back judge talking to his client. Can you mark this as conferring?
This will be the third contested matter on the court's docket, without on anything else.
Page 8, number 23.
Rogelio Martinez Jr. versus Erika Lynn Martinez, cause number 2025 FLB 1790C3. Court marks Mrs. Cotto present in person. Sergio Lozano, Attorney Lozano, are you present? Rogelio Martinez Jr., Erika Martinez, are you present? Court finds the parties are not present in person or on video conference. Mrs. Cotto.
Madeline Escoto for Mr. Martinez, Judge, Mr. Lozano and I came to an agreement. And so we've submitted to the court a settlement communication for purposes of the temporary orders. That includes provisions in the best interest of the minor child, as well as a temporary division of assets and debts. And Mr. Lozano signed it. My office e-filed it this morning, and the court should have a copy.
All well taken. Court has received, reviewed, and considered the signed Rule 11 agreement dated January 14th, 2016. The court has signed off on it. This is now a valid and enforceable court order. The final form of that temporary order is due to the court honor before.
January 26th at noon by submission.
And we'll come back for trial on the merits March 31st at 2 p.m. Anything else on this case, Mrs. Cotto?
Nothing further, Judge.
Page 9, number 24.
On recall, this is Ivan Dominguez Abigail Alonso, cause number 2025 FLC 602C3. Court marks Mrs. Cotto present in person, Ms. Maddox present in person, Ms. Garcia present by video conference. Ivan Dominguez Abigail Alonso, are you still present by video conference?
Yes.
Court
Yes.
marks Mr. Dominguez present by video conference and Ms. Alonso also present. Counsel, go ahead.
Judge Madeline Escoto for Mr. Dominguez.
Adriana Maddox present for Ms. Alonso.
Judge, with the assistance of Ms. Garcia, and we thank her, we have reached an agreement. Unfortunately, we were unable to e-file it, so we just tendered it to the clerk. Ms. Garcia, Ms. Maddox and I have signed, and we've signed Ms. Garcia's name with permission. We're asking that the court approve the same as being in the best interest of the minor child.
That's correct, Judge, and we'll prepare a more detailed order.
Sure. Ms. Garcia.
That's correct, Judge. We've been in discussions.
Court has received, reviewed, and considered this now converted communication, this Rule 11 agreement, noting multiple insertions by pen. The court adopts and approves it, has signed off on it. These are the orders of the court. The final form of those orders are due to the court honor before.
January the 26th at noon by submission.
I just want to confirm, Mrs. Cotto, Ms. Maddox, this resolves any pending matters?
Yes, Your Honor. Yes, it does.
All right. So I've given you an order's due date. That's what you're asking for. You're not asking for an entry.
An order's due date is fine.
All right. Ms. Garcia, there's a lot of work from all parties, but I've heard, the court has heard on the record that you've substantially helped the process. The court thanks you.
Thank you, Judge.
Mr. Dominguez, do you have any questions for the court?
I had one question on the papers and everything. I already know how everything's gonna come out too. The only thing is that the income tax, that if it was gonna stay, it's just a question. If it was gonna stay for Ms. Alonso, like we spoke, 1 year, or that is canceled.
That was canceled, Mr. Alonso, Mr. Dominguez. She claims them every year.
Okay, all right.
Do you have any other questions for the court, Mr. Dominguez?
No, sir.
Ms. Alonso, do you have any questions for the court?
No, Your Honor, thank you.
Well, you've concluded now your case through much work and effort and communication with each of you and your lawyers. I certainly congratulate you, wish you well, and wish you a peaceful 2026. Good luck to you.
Thank you, sir.
Likewise.
Page 11, number 30.
Judge, I have no further matters. That was my one case that was on recall. May I be excused?
Good to see you. Have a great year.
Thank you. You too.
It's Juan Arellano Jr. versus Emily Arellano, cause number 2026 FLB 22C3. Court marks Mrs. Cotto present in person. Juan Arellano Jr., Emily Arellano, are the parties present?
Not identified.
And Madeline Escoto for Mr. Arellano, Judge. Mr. Reyes just got hired. And as you know, as the court knows, I was out of my office. And so, they did it for Rule 11. I think they forgot that the court prefers those continuances. But I signed it. He just got hired. I have a settlement offer waiting to send to him. So, if we can just have your next temporary orders date.
Well, very well taken. Ms. Flores, give us another temporary order setting, please.
January 28th at 9 a.m.
Are there any other cases for Mrs. Cotto? All right.
Yeah.
First online is Counsel Nelly Salazar.
Cases for Ms. Soto.
Each one number one.
Adriana Ochoa versus Fernando Bouvier, cause number 2008 CVO 430C3. Good morning, Ms. Salazar.
Good morning, Your Honor.
Court marked you present by video conference. Court marks Mr. Elias Alcantar present and participating by video conference on behalf of the Attorney General's office. Are you Fernando Bouvier?
Yes, sir. Good morning.
Welcome to court, sir. The court marks you present participating by video conference. Are you at your lawyer's office?
Yes.
All right. Court marks you present participating by video conference from the office of your lawyer. Adriana Ochoa, are you present? Court finds Ms. Ochoa not present in person, not present and participating by video conference, and court takes notice that she was served with process on October 18th, 2025. Ms. Salazar, go ahead.
Yes, Your Honor. So we're here today for a motion to modify the parent-child relationship and also a motion to clarify possession and access. And Your Honor, we would also, I was gonna actually ask for a recall just to see if maybe I can confer with Mr. Alcantar or someone else from the OAG's office, because my client is also interested in asking for some possession credit, given the unique facts of the case.
I mean, I have to ask, Mr. Alcantar, any objection to conferring with Ms. Salazar?
Your Honor, we were not notified of this case. I don't believe we were given notice. I have no objection to conferring with her, though. If possible, though, I would request a short reset so that way I can have time to work on the numbers. If we can try to go forward today, we can try, but I would like some time if possible.
Yes, Your Honor, I'm completely understanding of that. I apologize. I tried to get in touch with the OAG's office, but I got in touch with Mr. Schamberger, so he doesn't come to CC2. So I do apologize on that, on my behalf. But yes, if
do you personally have Mr. Alcantar's contact information?
I do not.
You'd send it to her.
Okay, so just exchange that. That'll help the communication process. I could have you confer. I could just give you some more time to really review and make sure that you're in a good place for final hearing as you wish. Ms. Salazar, Mr. Alcantar?
Yes, Your Honor, I'd have no objection. I think this, I don't want to get into it, but the other case that I have on recall, I think it's going to take a little bit of time.
Right.
So I'd leave it to Ms. Salazar.
Yes, Your Honor, if possible, we could get a recall, or I understand Mr. Alcatan does have that other case pending. If we could meet later on today, whatever the court's preference is, and of course, whatever with Mr. Alcantar.
All right, so I tell you what, Ms. Flores, this is a first setting. No, this is good. So give us two settings, and I'll tell you why. Give us a final pretrial and push it on to a soon docket, 2 to 3 weeks. Final pretrial.
Sure. Final pretrial in 2 to 3 weeks, Your Honor?
More or less, yes.
That'll be February the 10th at 2 p.m.
And give us a final hearing date.
Final hearing, March 31st at 2 p.m.
So what the court is doing here, Mr. Bouvier, Ms. Salazar, and Mr. Alcantar, if you really only need a little amount of time, February 10th, you should be able to hold your final hearing. But on that date, if you don't, I just need to hear whether the office of the Attorney General's office has been contacted, whether they've had enough time to compile this information, digest it, give a report and recommendation. And if not, then we'll come back for final hearing on March 31st. So thoughts, comments, questions, objections, Ms. Salazar?
No objections, Your Honor.
Mr. Alcantar?
Your Honor, I'd have no objection. The only thing is, I believe, based on the case history, the mom hasn't been appearing. She has been she was served with substitute service, but she hasn't been appearing. So at the final pretrial, if she's not present, most likely it's going to have to be reset to give her notice of the final hearing.
Say that again. What?
I don't believe she's going to appear based on
Right.
prior case history. And if she doesn't appear at the February setting, most likely, since it's set for final pretrial, most likely we're going to have to reset it to the next day for actual final hearing to give her notice.
Well, then let me ask you this, if that's the request, any objection to setting the final hearing for February the 10th?
No, Your Honor.
Ms.
No
Salazar?
objection, Your Honor.
All right. Then final hearing scheduled for February the 10th at 2 p.m. So ordered. Mr. Bouvier, do you have any questions for the court?
The only question that I have is, I don't mind to come, just please, can you make it on Mondays? Because I'm a truck driver right now, and I most of the time I get out of town between Monday or Tuesday. And I would like if you can do it for me. If not, that's fine. I'm gonna do some changes with my dispatcher so I can come, or maybe I'm gonna do it on Zoom. Don't worry. Thank you.
Ms. Flores, does the court have any family law settings on Mondays?
No, Your Honor.
Right, so we don't have family law settings on Monday, but the reason we hold court and allow persons, lawyers, witnesses, clients, parties to participate by video conference is to accommodate for situations like that. If you are working and are on the road, the only thing the court is going to ask is that at the time your case is called, pull over to make sure that you're safe and not driving. You can participate fully by video conference. But
Okay.
we'll accommodate your work schedule like that.
Okay, man. Thank you very much, Your Honor.
Right, we'll see you here on February the 10th. I wish you well, Mr. Bouvier. Have a good day.
Thank you. You too, man. Thank you.
Those are all the matters for Council Salazar this morning.
It's good to see you, Ms. Salazar. Have a great day.
Likewise, Your Honor. Thank you so much.
Next online, Council Brenda Anderson, page 3, number 7.
Jose Israel Gaona versus Jocelyn A.D. Terrones, cause number 2024 FLI 1465C3. Court marks Ms. Anderson, present and participating by video conference. Ms. Leticia Garcia, present and participating by video conference. Mr. Elias Alcantar, present and participating by video conference. He's here on behalf of the Attorney General's office. Are you Jose Gaona?
Yes, Your Honor.
Welcome to court, Mr. Gaona. The court marks you present and participating by video conference. As you can see from your device, your lawyer is also present by video conference. Are you Jocelyn Terrones?
Yes, I am.
Welcome to court, Ms. Terrones. The court marks you present and participating by video conference. As you can no, Ms. Terrones, do you have a lawyer?
I do not.
Are you going forward without a lawyer? Are you?
Yes.
All right.
Yes,
the
I
court
am.
marks you self-represented. Ms. Anderson, announcement.
Good morning, Your Honor. I'm here present for Mr. Gaona. Your Honor, I did file a motion for continuance in this case because we have a few matters that are still pending. Mr. Del Barrio urged or requested to be withdrawn as Mr. Rones' counsel last time we were here, but there was no order that had been filed. I did reach out to him and he did file it like moments ago, or just this morning. He did file his order, so we're just pending for Your Honor to sign that order so that then we can communicate with Mr. Rones directly. It was just unclear beforehand. And Ms. Garcia is assisting us in trying to see if there is a possibility to reach agreement and avoid a hearing. So we also needed time to kind of finalize that situation.
Ms. Garcia?
That's correct, Judge. I was requesting financial information from both father and mother, but I did not want to impose on Mr. Del Barrio's position that he had not yet been formally withdrawn from the case. I'd like also for the court to just inquire of Ms. Terrones whether she intends to seek further counsel or not, so that we can be prepared for that as well.
Let me ask the court clerk and coordinator, what was the date of the hearing on the motion to withdraw?
On December the 4th, Your Honor, it was granted in open court, just their pending order that was filed today, Your Honor.
December 4th. I'm just asking so I can write it into that blank on that order. The court has signed this order. Mr. Del Barrio was withdrawn on that date. I've signed that order now. Ms. Terrones, will you at the final hearing date look to come with a lawyer, or are you going to represent yourself at the final hearing?
I'll be representing myself.
The court marks yourself represented. Ms. Flores, does the court have Ms. Terrones' email address?
Yes, Your Honor.
All right. Ms. Anderson, Ms. Garcia, and I guess everybody, how much time would be reasonable and necessary for that final hearing? 30, 60, 90?
30, Judge, is fine. Brenda?
Take 30. Yes, 30. I agree with 30 days.
Give us a final hearing date that approximates 30 days.
February the 24th at 2 p.m.
All right, so you're going to come back to court on February the 24th. Mr. Gaona, do you have any questions for the court?
No, Your Honor.
Ms. Terrones, any questions?
No, I do not.
Thoughts, comments, questions, objections? Mr. Alcantar?
No, Your Honor, thank you.
Ms. Garcia?
No, Judge, thanks.
Ms. Anderson?
No, Your Honor.
Mr. Gaona, Ms. Terrones, I wish you well. We'll see you on February the 24th. Good luck.
Thank you.
Thank you, Judge. That's all I have, Judge. May I be excused?
It's good to see you. Have a great day.
Next
you.
on line, Counsel Leticia Garcia, page 9, number 25.
Jenica Soraya Carrillo versus Jose Valentin Armenta, cause number 2025 FLE 976C3. Court marks Ms. Garcia present participating by video conference. Jenica Soraya Carrillo, Jose Valentin Armenta. Please step forward. Are you Jenica Soraya Carrillo?
Yes.
Welcome to court, Ms. Carrillo. The court marks you present in person. You are representing yourself, Ms. Carrillo?
Yes.
Court marks yourself represented. Are you Jose Valentin Armenta?
Oh, he's my husband. He's adopting my children.
Understood. Sir, what is your name?
Manuel Perez Gomez.
Mr. Gomez, the court marks you present in person. Mr. Gomez, are you going forward without a lawyer? Or are you going to hire a lawyer?
He only speaks Spanish.
We'll begin Spanish language interpretation now. Mr. Carrillo, excuse me, Mr. Perez Gomez, are you representing yourself or are you going to hire a lawyer?
Pérez, ¿se está representando usted mismo o usted va a contratar los servicios de un abogado?
No, yo solo.
Myself.
Court marks you self-represented. Jose Valentin Armenta, are you present? Court finds. Go ahead.
I think it's a waiver of service, Judge.
Court marks Mr. Armenta not present. Court takes notice that a waiver was filed January 14, 2026. There's a question pending before the court. Is the Office of the Attorney General involved? Mr. Alcantara?
No, Judge.
I don't believe so, Your Honor.
All right. Ms. Garcia, you are the court-appointed attorney ad litem. Are you ready to go
I am,
forward?
Judge. At the last hearing, the court would recall this was set originally just for a termination of two minor children of the parental rights of biological father. At that point in time, I did announce to the court that the intention of mother, after I spoke with her, was that we were going to convert this termination into a joint termination and adoption by the prospective stepfather, who is married to mother at this point. And I had a great conversation 2 nights ago with the parents, prospective, with Mr. Manuel, the 2 kids and mother. And yes, I am ready to give a recommendation that the termination be accepted, signed by the court, and proceed with the adoption. I'm confident that that is the right decision for the children in this case, and would ask the court, would the court prefer that I elicit some testimony, or would the court do the testimony from the pro se
Just pausing for a little bit, Ms. Garcia, for translation to conclude. Ms. Garcia, you are the court-appointed attorney ad litem. Court finds that if you think that it is in their best interest, there is no conflict for you to elicit the testimony. Therefore, Ms. Carrillo and Mr. Perez Gomez, please raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth? So help you God?
Yes.
Both have answered yes. You may lower your hands. Ms. Garcia, one witness at a time, 1 to 2 sentences total. Go ahead.
If I may start with Mr. Pettis, Judge.
On the termination?
Oh, okay. That's right. Let me go with mom. Ma'am, please state your full name for the record.
Jenica Soraya Carrillo Perez
Ma'am, where do you reside?
at 505 North Martin Avenue here in Laredo, Texas.
And please announce and identify the children, the two kids that are the subject of the matter of this case.
It's Ricardo Ángel Armenta and Destiny Shailene Armenta.
Can you give me the dates of birth, please, of both children?
Ricardo is November 22nd of 2016. Destiny is November 9th of 2017.
And who is their father, biological father?
Jose Valentin Armenta.
And is it true that you personally filed affidavits of relinquishment by and between Mr. Armenta and your two children?
Yes, that's true.
And is it also true, and I know whether you have personal knowledge of this, that I myself spoke with Mr. Armenta during the process of this case?
Yes, that's correct.
And are you asking that this court terminate the parent-child relationship between Mr. Armenta and your two children?
Yes.
Do you believe that because he had very limited visitation periods or possession or custody of the children, that this is the correct thing to do?
Yes, that's correct.
Is it true that he never paid any child support for the children?
That is correct.
And that he never regularly visited nor inquired of the children, is that correct?
That is correct.
And for those reasons, you believe that it is in the best interest that termination be granted?
Yes.
Judge, if I may then move on to Mr. Bettis.
Go ahead.
Sir, please state your name for the record.
Manuel Pérez Gómez.
Manuel Pérez Gómez.
And where do you reside?
505 North Martin Avenue.
505 North Martin Avenue.
And how long have you lived with Ms. Armenta?
Para 2 años.
It's about to be 2 years.
And are you formally married with her?
Sí.
Yes.
What is your date of marriage?
El 5 de mayo de 2025.
May the 5th of 2025.
Mr. Perez, you have asked to become the legal father of Ms. Armenta's 2 young children. Is that correct?
Sí.
Yes.
Do you intend to support those 2 children financially,
Sí.
Yes.
educationally,
Sí.
Yes.
and spiritually?
Sí.
Yes.
Do you understand that in the event of a divorce between you and Ms. Armenta, you can be ordered to provide child support for those 2 children?
Yes.
Do you believe that it is in the best interests of these children that you be appointed their legal father?
Sí.
Yes.
Is it also true, Mr. Perez, that you and Ms. Armenta just recently had a baby?
Sí.
Yes.
And the baby that I got to meet is just 5 days old.
Sí.
Yes.
And that Miss Armenta has an older child as well, who is, I think, 15 or 16.
Sí.
Yes.
And all of you live as a family unit together in the same residence, correct?
Sí.
Yes.
Are you asking the court to appoint you the legal father of the two children at this point?
Sí.
Yes.
Judge, it is again my recommendation that the court terminate the parent-child relationship between the two children and Mr. Armenta, and thereafter, of course, grant Mr. Perez's request to be appointed father of these kids. I think there's an order on file as well.
Oh.
And that the names, the last names are set forth for the change of names to the children. And Ms. Armenta, if I get this right, the last names are going to be Carrillo Perez for both
Yes.
of the kids, correct?
Yes, that's correct.
We request that as well, Judge.
Sí.
Several questions. First question to Ms. Garcia. You are the court-appointed ad litem for the children in this case. Is there anything you want to share with the court regarding fees?
No, Your Honor. In fact, she did pay fees when I saw them a couple of nights ago. So that's settled. Thank you.
Next question, Ms. Carrillo Perez. I heard the birth dates. How old is your son?
9,
And how old is your daughter?
8.
All right. Last question to you, Mr. Perez Gomez. How long have you lived with the 8 and 9-year-old?
Como 1 año y 6 meses más o menos.
Around a year and 6 months.
Do they, what if anything, do they call you?
Papa.
Dad.
All right. And final questions. Do you understand that if the court grants the request, your obligations to these children are indefinite?
Yes.
Many people believe that their obligations with their children end when they turn 18 or graduate from high school. That's not the case. Parents have legal and moral obligations with their children even until they die. And then at the time of death, your estate has continuing legal obligations to your children. Knowing all of this, you want this adoption.
Yes.
All right. Ms. Carrillo Perez, Mr. Perez Gomez, in this case, cause number 2025 FLE 976C3, the court finds that it has jurisdiction. The court finds that respondent Armenta has filed a waiver. Having considered the testimony and evidence in this case, the court finds that there has been limited, if any, visitation between father and children. The court further finds that no support whatsoever has ever been paid. Considering all of these things and the testimony, the court finds that it is in the best interest of these children to grant the termination. Mr. Armenta's rights are hereby terminated. The court now turns to the adoption The court finds that these two children have lived with Mr. Perez Gomez for a year and a half. The court finds that they call him dad. Because in their mind, you are their dad. I get to do now legally what is going on in your house, and I get to grant this adoption because you are their dad. Congratulations.
Yes.
Give me a second to review your order so that I can finalize this adoption.
Oh. Yes.
To confirm your request, Ms. Carrillo Perez the name changes to Ricardo Ángel Carrillo Perez and Destiny Shailene Carrillo Perez.
Yes, that's
Well,
correct.
Ms. Garcia, to confirm, you did elicit testimony as to the sealing of this case, correct? I'm pretty sure I heard it. I just want to confirm. Ms. Garcia?
I'm sorry, Judge, I didn't hear that. There was a call coming in.
I think you elicited testimony and the parties requested that the court seal this case. Is that right?
Yes, Judge.
That's what I recall. I didn't see that language, so I've added in additional language that the court has been requested to seal this case. The court finds that doing so is in the children's best interest, and it is so ordered. Ms. Carrillo Perez, Mr. Perez Gomez, the court has granted your request. I have signed your order. Your orders are final, and your family is complete. Congratulations.
Thank you, Judge.
Gracias.
Have a great day.
Thank you, Judge. I've got nothing further, but excused.
Great to see you, Ms. Garcia. Have a
Thanks,
good day.
Judge. Have a good day.
Next online, Counsel Juan Jose Garcia, page 8, number 22.
Elizabeth Adriana Alos Fernandez versus Jose Antonio Fernandez Perez, cause number 2025 FLB 1530C3. Good morning, Mr. Garcia.
Good morning, Your Honor.
Court martial present by video conference. Step in front of the microphone and tell the court, are you Elizabeth Adriana Alos Fernandez?
¿Es usted Elizabeth Adriana Alos Fernández?
Sí, sí, señorita.
Yes, Your Honor.
The court martial present in person.
El tribunal le marca presente en persona.
As you can see from the screen, your lawyer is present by video conference.
Como usted puede ver por la pantalla, su abogado se encuentra presente por medio de videoconferencia.
Jose Antonio Fernandez Perez, are you present? Court finds Mr. Perez is not present in person, not present by video conference, and takes notice that a waiver is on file since December 5th, 2025. Mr. Garcia?
In this case, Your Honor, there was a tentative agreement. However, there's some bank accounts that the respondent has that my client wants me to do a little bit of discovery of before reaching an agreement with him. So we would just like to request, is this the first setting, Your Honor? We'd like to request just another setting so I can do a little bit of discovery and just find out what the accounts have and what are the amounts of that.
So for setting, by policy of the court, the request is well taken. Since this involves discovery, Ms. Flores, give us two settings, a final pretrial and a final hearing date.
Yes, Your Honor. Final pretrial. February the 10th at 2 p.m. And final hearing March 31st at 2 p.m.
Ms. Fernandez, do you have any questions for the court?
No, él renunció a... Es que le había quedado que todo iba a estar de acuerdo. Me iba a dar mitad de todo, pero no ha dado cuenta, no ha dado nada. Pues, lo sigue. No, su señoría.
No, Your Honor. I know that he gave up his certain things, like he was going to give me half of things, but he hasn't given any information. So I understand.
All right, very well. We'll see you here on February the 10th. Good luck.
Thank you.
Page 10, number 29.
Anthony Composto versus Chantal Jasmine Composto, cause number 2026, FLA 31C3. Court marks Mr. Garcia present and participating by video conference. Anthony Composto, Chantal Composto, if you're present, please step forward. Speak into the microphone and tell the court, are you Chantal Composto?
Yes, Your Honor.
Welcome to court, ma'am. The court marks you present in person. Do you have a lawyer?
Yes, sir.
Who is your lawyer?
Mr. Alget.
Yes, Your Honor, I did confer with Mr. Alco and we reached an agreement for the temporary orders and I signed off on them last night and sent it to Mr. Alco.
Mr. Altgeld, are you present? Court finds Mr. Altgeld not present. Are you Anthony Composto?
Present.
Court marks you present by video conference. As you can see and hear from your device, your lawyer is also present by video conference.
Thank you.
Mr. Composto, Ms. Composto, the court has received, reviewed, and considered your agreed temporary orders. They are in due form. I have signed them, handing the original to the clerk's office. And then you're going to come back for your final hearing, your trial on the merits on April the 2nd at 9 a.m. Mr. Composto, do you have any questions for the court?
No, Your Honor.
Mrs. Composto, do you have any questions?
No.
All right. Keep in contact with your lawyers between now and when you come back on April the 2nd. I wish you both well. Good luck.
Thank you, Your Honor.
Those are all the matters for Counsel Garcia.
It's good to see you, Mr. Garcia. Have a great day.
In here, Judge, thank you.
Thanks.
I think just the ones on recall, Your Honor.
Let me hear some announcements where you're at, and then the court will pause momentarily. First case on recall, page 3, case A, Trilene Hernandez Martin Ramiro Maldonado III, cause number 2024 FLI 1859C3. Court marks Mr. Del Rio present in person, Mr. Peña present participating by video conference, Trilene Hernandez by video conference, and Mr. Maldonado present in person. Mr. Peña, Mr. Del Rio, announcements.
Your Honor, we've actually been back and forth in weeks past. So at this point, we're just miles apart with visitation So we do need a hearing, Your Honor.
That's correct, Your Honor. We're here for temporary orders, and we've sent proposals back and forth, and I think like out of 10 things, we have agreed to 2 of them. And so we do need, my client would like to make some requests, and she would like to testify.
All right. Well, you're the first contested matter, but let me see if I can get you to a good place and see if I can cut through some of the testimony with facts that should not be in dispute. You were the petitioner, Mr. Peña. How many children before the court?
Actually, Your Honor, I'm the petitioner.
No, Mr. Del Rio's client
It's
is the
the petition
petitioner.
to modify. You're absolutely right. They're inverted because at the initial setting, at the initial filing, you were the respondent. You're now the petitioner asking for modification. Well taken, Mr. Del Rio. How many children before the court?
It's 2 children, Your Honor.
Their ages?
Age 4 and 2.
Their genders?
Male, 4 years old, female, 2 years old.
Mr. Peña, true?
Correct, Your Honor.
All right. Mr. Del Rio, with whom do these children primarily reside?
With mother, Your Honor.
Mr. Peña, true?
That is correct, Your Honor.
Mr. Del Rio, does the 4-year-old or either or both attend any educational institutions?
No, Your Honor.
Mr. Peña, true?
My understanding is that the older child is being enrolled in school in Washington State, and I encourage my client, Raylene Hernandez, to correct me if I'm wrong.
Ms. Hernandez, does your 4-year-old attend any educational facility?
He will be starting on Monday.
So not now, very soon. Understood.
Yes.
These children reside with Mr. Peña's client, Ms. Hernandez. Ostensibly, without knowing anything else, the court would institute a standard possession order with modifications for the 2-year-old until that child turns 3. Mr. Del Rio, this is your request. What information, evidence, and testimony do you intend to show the court to do otherwise?
We would agree with that, Your Honor. The issue is that mother has been bouncing back from Laredo to Washington State, where the children are now. My client has not had possession of the children since December 12th and missing his holiday visitation.
My client has moved to Washington State. That's correct.
So the request, let me just finish with Mr. Del Rio so that I can get the full, and these things, if at some point there's a disagreement as to the facts, I'll stop and then we'll start the hearing. But so it sounds like, Mr. Del Rio, if you're not requesting anything other than, so you're not here to prove anything other than standard possession, then is the dispute makeup time, or what is the dispute?
The dispute is essentially
what is it you're asking that Mr. Peña doesn't agree with?
Well, basically how the cost to get the children from Washington State to here is going to be paid by. That's one. They're requesting that it's split. We're requesting she exclusively cover that cost. And then the frequency of the visits is in dispute. Their last proposal was 4 days. We had said once one month on, 1 month off, temporarily to help mom with the cost. That had been sort of the visitation period prior to filing this suit. And that's frequency and cost of transportation of the children are the big issues, Your Honor.
So, Mr. Peña, Mr. Del Rio says no issues with a standard possession order for persons that live 100 miles apart. What is at issue is how much time and the cost. True or not true?
Well, Your Honor, I'm not 100% certain of that. Let me just be very clear about this. I believe that once my client moved, we would be falling into the part of the order that says parents who reside 100 or more miles apart. And I'm not sure that Mr. Del Rio and I even agree that that's the applicable portion. But if it is, then we already have a standard visitation schedule in place for parents who reside more than 100 miles apart. And he is correct that in that situation, we would really only be arguing. Today, I think we're only really arguing about burdens and costs.
Well, in that scenario, applying the standard possession order, the testimony will hinge on your client's affirmation as to her residence. Mr. Peña, when placed under oath and asked the question, where does your client reside?
She will testify under oath that she and the two children reside in Washington State. Forgive me, I do not recall the name of the specific city.
That's fine. No dispute thus far, Mr. Del Rio?
We would challenge that, given that she does still have residence here in Texas. She has an apartment, and she has not exclusively resided in Washington State. It's been a 1 month on, 1 month off sort of visits. She's been back and forth between the two. So I don't believe, and she's also my client would also testify that she's told him she intends to move to San Antonio at some point. So we don't believe Washington is her permanent residence right now.
Mr. Peña, is Mr. Del Rio going to be able to show these things by evidence and testimony to the court?
No, we disagree, Your Honor. My client is going to testify that her intention is to permanently live in Washington State. Now, Mr. Del Rio is correct in the sense that my client has come back to Laredo, but she's only come back to Laredo for purposes of affording the father visitation. And she stays here while the father is visiting with the child. And then after the visitations, they go back to Washington State. So in one sense, what Mr. Del Rio is saying is accurate, but I don't think the spirit in which he is saying it is correct.
Yeah, I can see how the court's going to have to make a determination as to residence and then apply the specific statutory provisions of the family code that applies to these folks in their situation. All right.
That's correct, Your Honor. That's correct.
Right.
We're probably going to need a hearing, and my client would like to testify.
Sure. We'll put your client on momentarily. All right, stand by.
Thank you, Your Honor.
Yes, Your Honor.
Page 1, number 2. Galinda de los Santos, Eduardo de los Santos, cause number 2018, FLA 500C3. Court marks Mrs. Cotto present. Somewhere here in court. Mr. Martinez King present, participating by video conference. Eduardo de los Santos is not present. Galinda de los Santos, are you now present?
Music bomb. Drama box. Street drama shorts. Reborn.
Are you Galinda de los Santos? There's an unmute button at the bottom left of your, yes. Are you Galinda de los Santos?
Sí. Yes.
Court marks you present by video conference.
Tribunal le marca presente por medio de videoconferencia.
Mr. Martinez King, have you had sufficient time to talk to Ms. Cotto?
Not with Mrs. Cotto. I sent her an email. I don't know if she saw it, but I did get a chance to confer with our client, and we did take a look at the numbers that were discussed. Our client is in agreement with a portion of it, and then the other portion will probably have to go into final hearing for it.
No he hablado con la abogada Scotto, sin embargo, le mandé un correo electrónico. Mi cliente está de acuerdo con ciertos números, sin embargo, la otra parte lo llevaremos a la audiencia final.
Right, stand by. Mrs. Cotto is before the 406 right now. Stand by.
En un momento hablaremos sobre este caso.
The court takes notice that Mrs. Cotto is also present and the attorney on the third matter pending before the court. It's 12:13. I tell you what, let's come back at 1 p.m. Court will resume court in about 47 minutes. Stand by. Good afternoon. Court is once more in session. This is the family law docket for Thursday, January 15, 2026. The time is now 1:42. There are three cases pending hearing. Mrs. Cotto, you have two. Which would you like the court to consider first? Is this the Flores matter?
Inaudible.
Sorry, there you go.
This is page 6, case 17, Elizabeth Flores for Armando Flores, cause number 2025 FLB 863C3. Court marks Ms. Cotto present in person. Counsel, your name is Frank
Inaudible.
Gonzalez. Court marks Mr. Gonzalez. Counsel Gonzalez present in person. Are you Elizabeth Flores? Unmute your device, please.
On the left-hand side, on the bottom, Ms. Flores.
We'll go with Mrs. Cotto's affirmation. This is your client?
That's my client, Judge.
Court marks Ms. Flores present and participating by video conference. Is this your client in court, Mr. Gonzalez Jorge Armando Flores?
Yes, Your Honor, it is.
Welcome to court, Mr. Flores. Court marks you present in person. You're joining your lawyer. Counsel, go ahead.
Judge, we've reached an agreement. Obviously, we did attend mediation with Judge Hale. We're unsuccessful, but we were able to flush out the remaining issues, and we have an agreement today that I'd like to put on the record.
Yes, ma'am, go ahead.
Judge, the parties have agreed to the jurisdiction of the court. The parties have agreed to be divorced on the grounds of insupportability with no expectation of reconciliation. The parties have agreed that no child was born of the marriage and none is expected. The parties have agreed that the following is a just and right division of the estate. Ms. Flores will be awarded a 2012 Ford Expedition, her personal belongings, her bank account, her retirement, as well as a property and mobile home located at 1902 Davis in Laredo, Texas. And that includes the rental income on that property beginning February 1st of 2026. And all of the contents located at 3314 Holstein Lane, also located in Laredo, Texas. She will also be awarded on January the 20th, $500 in rental income that was collected by Mr. Flores on the 1902 Davis property. Mr. Flores will be awarded the following: a 2020 GMC Sierra, a 2003 HD motorcycle, a 2015 Suzuki motorcycle, his personal belongings, a master bedroom set that is located at, the master bedroom bed that is located at 3314 Holstein, and he will be picking that up on Saturday, January 24th at 2 p.m. His personal belongings, and he's also being awarded his bank account, his retirement, if any. There is a Glock Springfield 9mm at a Ruger at Holstein, and so the parties have agreed that he'll pick those up as well on January 24th. And Mr. Gonzalez will prepare the transfer documents. If a 1911 Bellini shotgun is not found, then Mr. Flores has the option of reporting that stolen. He'll be awarded the real property located at 5304 Terrell Lane, and he will also be awarded a business known as Vision AC and Heating LLC, including all the equipment, accounts payables, accounts receivables, bank accounts, etc. With regards to the debts, Ms. Flores will keep her car insurance on her expedition, her cell phone, her credit card debts, and any debts she's incurred since the date of separation. Mr. Flores will be awarded the debt of the 2020 GMC Sierra, his cell phone, his credit card debts, including the Synchrony card that's associated with that master bedroom bed, and any and all debts and tax liabilities associated with Vision AC and Heating, and any debts he's incurred since the date of separations. The parties have already filed their 2024 tax return. They've agreed that the refund, when provided by the IRS, will be divided 50-50. Mr. Flores is awarded 100% of any liabilities, penalties, and interest owed by Vision AC, and he'll hold and indemnify wife harmless of the same For 2025, they'll file separate tax return and each will be responsible for their respective earnings, losses, and wages. Any and all tax liabilities owed by Vision, again, from the date of marriage to date of divorce are 100% awarded to Mr. Flores. Mr. Flores will ensure that the ad valorem taxes owed on 5304 Terrell Lane and 1902 Davis be paid on or before May 31st or as the deadline by the taxing entities. Beginning January 1st, 2026, Ms. Flores will be responsible for the ad valorem taxes at 1902 Davis, and beginning January 1st of 2026, Mr. Flores will be responsible for the ad valorem taxes on 5304 Terrell. The parties have agreed that Mr. Flores will not owe Ms. Flores the monies owed pursuant to the Rule 11 agreement and the temporary orders that were part of the motion to enforce. The parties have agreed that each party will pay their own attorney fees, and to the extent the deed is recorded, Ms. Flores' separate property is confirmed as 3314 Holstein. She wants a name change to Elizabeth Pineda. And I think I said, and everybody's paying their own attorney fees.
That is essentially correct, Judge. I would just add that the bedroom furniture that is being awarded to my client would cover any of the furniture in that bedroom that is still owed under the Synchrony credit card debt that he's assuming.
That is correct.
It may be just the bed, but I want him to clarify that just for clarification purposes, and that we would be able to retrieve his weapons, his personal items, and any titles to the vehicles he's being awarded by Ms. Flores on or before on January the 24th at 2 p.m.
That is correct, Judge. And we've agreed that I'll prepare the decree. We've agreed that Mr. Gonzalez will prepare the deeds and the transfer documents on the weapons, as long as he has those to me by before the 24th. That way we can do everything simultaneously.
Absolutely.
Ms. Flores, find the unmute button at the bottom left of your screen, please. It's a microphone. Look for it. A red button or a microphone button at the bottom left of your device. Swipe right if necessary. As she does that, Mr. Flores, make your way to the front of the lower bench. Pull a microphone close to you. Bottom left.
On the bottom left, Ms. Flores, you'll see a little microphone in red. Just press that.
You should now be seeing what that looks for, a white microphone with a red slash that says unmute. Press it to unmute.
It doesn't, she's saying that she sees it, but it's not letting her do it. I can represent to the court that this is the agreement of Ms. Flores, Judge. As an officer of the court, I've gone over it with her. She is the petitioner in this case. I can stipulate to the fact that she's been living in the state of Texas for the last 6 months and in Webb County for the last 90 days. I can before the filing, I can stipulate that we attended mediation with Judge Hale. I can stipulate that through further negotiations, this agreement was reached to by way of this morning, Judge, and I can stipulate to the fact that as an officer of the court, I went over the entire agreement with her. She is in agreement with all of the terms. She's asking that the court grant the divorce today, pronounce and render, and I can also stipulate, and as an officer of the courts, tell the court that there is no expectation of reconciliation in this case.
Ms. Flores, if you can hear everything, give me a thumbs up. Same. So, Ms. Flores, have you heard everything that your lawyer has said? Court has seen 2 thumbs up. And Ms. Flores, are you in agreement with everything your lawyer has said? All right, court has indicated and gotten an affirmative sign through a thumbs up. Mr. Gonzalez, would you like to confirm all of this with your client under oath? Are you good as is?
Well, Judge, I believe that, he is representing the court that is the.
Inaudible.
Into the microphone, please.
Yes, I'm so sorry, Judge. I can represent to the court as an officer of the court that this is the agreement that we have discussed in detail in the back. He is a Spanish speaker, Judge. My Spanish is not so good that I didn't require the assistance of someone, a close personal friend of his, that he brought to interpret. But based upon everything that we have discussed, this is the agreement that we've reached.
All right, Ms. Flores and Mr. Flores, in your case, cause number 2025 FLB 863C3, the court at this time finds that it has jurisdiction by stipulation over this case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage, but that marriage has become insupportable due to a discord or conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were no children born in the marriage, none were adopted, none are expected. The court has heard your agreement regarding the division of your property. The court hereby adopts and approves your agreement and finds that it is a just and right division. So ordered. Ms. Flores, at this time, the court changes your name to Elizabeth P. Pineda. And at this time, Ms. Pineda and Mr. Flores, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court that are due to the court on or before
January 26th at noon by submission.
Anything else on this case, Mrs. Cotto?
No, nothing further, Judge.
Mr. Gonzalez?
Nothing further, Your Honor. Thank you.
Ms. Pineda, Mr. Flores, I wish you both well. Mr. Gonzalez, have safe travels back home. Good luck.
Thank you, Judge. May we be excused?
Yes, sir.
Thank you.
Thank you, Judge. I have one more, Judge.
For the record, Ms. Pineda, Mr. Flores, I do acknowledge your patience. The court has not sat down since I last got off. This is the first time I have sat down, so I appreciate your patience and I acknowledge your patience. Second case for Mrs. Cotto, page 1. Case 2, Galinda de los Santos, Eduardo de los Santos, cause number 2018 FLA 500C3. Court marks Mrs. Cotto present in person, Mr. Alberto Martinez King present and participating by video conference. Ms. Santos is or was present by video conference. Mr. de los Santos is not present. Mrs. Cotto, Mr. King.
Judge Madeline Escoto for Mr. De Los Santos. Judge, we're going to request a short reset, being that Mr. King just got on the case. Catherine Garcia had spoken to the parties. It looks like we're in agreement to the possession credits, and that there is no agreement now with regards to the cohabitation credits, notwithstanding what Ms. Galindo had told the Attorney General's office. So we're going to need a short hearing on the cohabitation credits, but at a later time, so I can tender to Mr. King my evidence for his review.
That is correct, Judge.
I think Mr. Alcantar wants to put on the record at least, so we can get that out of the way, the possession credits, that those are agreed to.
Mr. Alcantar, the floor is yours.
Yes, Your Honor. And Your Honor, these are the numbers that I had read previously that the parties did agree to possession from February 2025 until September 2025. The request for us at the next hearing is going to be to take judgments as of July 31st, 2025, because the temporary order started August 1st, 2025. So I'm going to be going from February until July. The total amount, including interest, was $4,040.94. And I believe this was agreed to by the parties.
And I'll stipulate that that is correct, Judge, on behalf of Mr. De Los Santos.
All right, Ms. Flores, it sounds like this is going to take at least 30 to 45 minutes at a hearing. So give us a setting that doesn't have more than 22 cases, maybe.
Looking into it, Your Honor.
And obviously, Mr. King, Mr. Scotto, should there be any agreement before then, we'll be happy to sign off on it.
Yes, sir.
And how much time though, Your Honor? February, March setting?
something that doesn't have a lot of cases, so I can give them the right amount of time.
March 5th at 9 a.m.
Any questions for the court, Ms. De Los Santos? Court has seen no. All right. Anything else, Mr. King, Mrs. Cotto, or Mr. Alcantara?
No, Your Honor.
It's good to see everyone.
Mr. King, and you'll stipulate that those possession credit numbers are correct and you're agreeing to the same, correct?
We do stipulate.
Okay, perfect.
All right.
Thank you, Judge.
I'll
That's
see you
all I
here on
have.
March the 5th. I wish everyone well.
May we be excused?
Yes, good to
Thank
see
you.
everyone.
See you,
Have a great day.
Thank you, Your
And
Honor.
Thank you, Judge.
off the record, thank you for the consideration the court gave me this week. I appreciate it.
All right, that leaves one case pending. This is page 3, case 8, Hernandez versus Maldonado, cause number 2024 FLI 1859C3. Mr. Peña is present by video. I see. That your materials were still in court. Those are Mrs. Cotto's, Mr. Del Rio. You are now present and participating by video conference, as is Mr. Peña. Mr. Maldonado is present by video conference. Is Ms. Hernandez present?
I believe she is present, Your Honor. She's logged on. I see her her name, but she doesn't seem to be visible to me.
Ms. Raylene Hernandez, I'm going to ask that you start your video and turn on your microphone, please. Court is making that request electronically now. Court staff has admitted Ms. Hernandez's device into the waiting room to troubleshoot.
My client, she's having a little bit of difficulty in the lobby for some reason, and that she's logging on right now.
Court is admitting that device. 2 devices.
There we go.
I'm going to ask that you unmute your device. Are you Raylene Hernandez?
Yes.
Welcome to court, Ms. Hernandez. Court marks you present participating by video conference. Mr. Maldonado, unmute your device. Are you Martin Maldonado?
Yes, Your Honor.
All right. Welcome to court, Mr. Maldonado. Welcome to court, Ms. Hernandez. This is your motion. I think I've gotten all of the background facts. So just go straight into the facts that are contested or that what prove up or defend each position. Mr. Maldonado, Ms. Hernandez, please raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Yes, Your Honor.
Both have answered yes. You may lower your hands. This is your case in chief. Mr. Del Rio, you may proceed. Mr. Del Rio? There is 0 audio from your device. Bottom left of your screen, there should be a join audio button. Make sure that that is fully activated because you're not on mute. Your Zoom doesn't have access to your audio. Or your device doesn't have audio, one of the two. There it is, unmute. Go ahead. Try again, Mr.
Can you hear me
Del Rio.
now, Judge?
Yes, go ahead.
Okay.
Both parties are
All
under
right.
oath.
Thank you, Judge. All right.
Proceed.
Thank you, Your Honor. I was going to begin with Ms. Hernandez regarding the issue of residence, Judge.
Ms. Hernandez, you're under oath. The lawyers are going to ask you some questions. If you hear them object, pause your answer. If you don't know the answer, you need to say that because you're under oath. You need to be honest. Mr. Del Rio, you may proceed.
Thank you. Ms. Hernandez, it's true that beginning in June, you had removed the children from Texas and they were staying with you in Washington State. Is that correct?
Yes.
And you would leave for a month, return with them for a month. Is that also correct?
Sometimes.
Was it that you would sometimes stay 2 months away and come back for 1 month?
Yes, but I would take the kids. I didn't stay in Laredo for a whole month at a time, no.
Okay, but the children would be there in Laredo for a month with Mr. Maldonado, correct?
Only because it was his summer visitation. According to our plan,
Okay, but
that's why they would be there for that long.
okay, but he also had them for the month of August, correct?
Yes, because that's what we agreed on.
Okay,
As-
and
As part of the summer.
then you, after August, he had them for the entire month of August, correct?
Yes.
Okay, and you were staying in Laredo that entire month yourself?
No.
Okay. And you then took the children back from him on September until November 24th. Is that correct? End
Yeah.
of September to November 24th?
Yes.
And then Mr. Hernandez had them on November 24th until the beginning of or mid-December, correct?
Their father had them during Thanksgiving break. And then kept my daughter a little bit longer.
Now, you still had a home in Laredo, correct?
An apartment? Yes.
Okay. And you're still paying rent on that, correct?
Yes.
Okay. Where do you live in Washington State?
In Des Moines, my address is 27046 10th Avenue South.
Okay. And you own that residence?
No.
Is it a apartment or a home?
It's a home I rent.
Okay. Who do you rent with?
Like, who do I pay or?
No, who do you live with in the home?
My boyfriend.
Okay. And I'm sorry, go ahead. I'm sorry, go ahead.
And a cleaner.
A cleaner?
Yes.
Like a live-in housekeeper, I guess?
Yes.
Okay. And is your name on the lease agreement?
Yes.
Okay, and you could produce a copy of that?
Yes.
Okay. And how long is the lease for?
I believe it is till April.
Okay. And how long is your lease for the Laredo apartment?
That lease was for 1 year. It started in 2021. And then moving on after that, it's just month to month.
And so you moved first, I guess, stayed in Washington back in June, is that correct?
Yes.
So June, July, August, September, October, November, December. So it's been 7 months that you have not terminated your lease here in Laredo, even though it's month to month.
Yes.
Okay. Have you registered to vote in Washington State?
No.
Do you have a bank account?
Yes.
Have you changed the account mailing address to your Washington State residence? Okay. Do you have a vehicle?
I didn't hear that. What was the answer to the changing of the bank account?
Yes.
Okay. Do you already have a state ID?
I do not.
Okay. Do you have a vehicle?
No.
Okay. And I think Mr. Benny had mentioned that you are about to enroll your 4-year-old into a daycare program.
It's preschool. He just turned 4 in September, so he couldn't start preschool till he they told me that he could start Monday. There's a slot available now. So yes.
Is it a private school or public school?
A public school.
Are you aware that Monday is a national holiday and there are no schools on Monday? It's Martin Luther King Day.
No, they told me, as far as I know right now, Friday I'm supposed to go to meet with the teacher, and then they said school would start for him on Monday.
Okay, so you haven't.
Are you on your cell phone? Are you logged in through your cell phone?
No. Oh, meet
Are you on a computer or on a cell phone?
an iPad?
Do you have your notifications on your iPad?
I don't think so. I don't think it's coming from.
Are you getting constant notifications?
I don't think that's. I hear it. I don't think that's coming.
Mr. Del Rio, it's either your or Ms. Hernandez's device.
I'm not receiving any text, Judge, or anything, so I don't know.
Yeah, I hear that.
I hear.
Don't.
I don't think
And
it's
my phone is
Mr. Peña because they're on mute.
correct.
Court. All right. We'll proceed. Go ahead, Mr. Del Rio.
Okay, and then as far as the home that you're renting, you said your name is on the lease agreement, right?
Yes.
Okay. Are any of the utilities under your name?
No.
Okay. And what was the reason to move to Washington State?
Better opportunities, work opportunities.
Okay. Isn't it true that last month you had told Mr. Maldonado that you plan to move back to Texas, specifically San Antonio, in the near future?
Yes.
Okay. And you haven't registered to vote. You don't have a vehicle. Do you have a vehicle in Texas?
No.
Okay. All right. And I will. And every time when you would conduct an exchange here in Laredo, the exchanges would occur at your apartment here in Laredo, Texas, correct?
Sometimes at my apartment, sometimes at their father's home.
And again, lastly, so you do plan to at some point return to San Antonio or move to San Antonio?
Sometime in the future, yes.
Okay. And now the reason you moved, isn't it true the reason you moved those because you could to work with your stay with your boyfriend?
Not necessarily. For work, like I mentioned.
Are you employed?
Yes.
Where do you work?
I clean Airbnbs.
You clean Airbnb
Cleaner, yes.
homes?
I'm sorry?
Okay. Like you clean the Airbnb homes?
Yes.
Okay. Did you work here in Texas?
I did at a restaurant.
What did you do here in Texas? At a restaurant.
Mm-hmm.
So you moved to Washington State for better opportunities, but now you're cleaning Airbnb homes.
Mm-hmm. Yes. I get paid more and I get to bring my children with me to work.
Okay.
Thus avoiding not having to pay childcare. So.
All right. And Are your children are still enrolled under Texas health insurance? Are you aware of that?
No, they have Apple Health in Washington.
Yes, so you have not unenrolled your children from Texas Medicaid. You have not done that.
Their Medicaid had to be renewed, which I never renewed. I then applied in Washington for Medicaid. So they have Medicaid through the state of Washington.
But they also have it here in Texas as they're still charging my client for medical reimbursement.
Not that I'm aware of. Last that I knew, it was up for renewal, which I did not do. I applied here in the state of Washington. They go to the doctor here. They have a pediatrician here, a dentist.
And can you provide all that information?
Yes.
Okay. And when do you plan to return to Texas?
I don't have an exact timeline or time frame.
Okay. And is it true that my client has not seen his children since December 12th?
Correct.
Okay. And you were aware that this year he had his New Year's visitation, correct?
Correct.
And you did not bring the children back so he could exercise his New Year's visitation, correct?
Correct. He kept them longer for Thanksgiving break. So I don't see, he took his time then.
And let me ask you this. My client has never agreed with you dropping them off for 1 month and then you taking them for 2 months and then returning them for 1 month. Isn't that correct?
It was discussed.
But my client did oppose it.
It was discussed, and that's what we followed for a few months.
Okay, but again, my question is, did my client disagree with it, even though he went along with it?
Your Honor, he's asking her to read his client's mind, Your Honor. That's an improper question.
No, I'm asking if he either in text or verbally communicated to her he was not in agreement with this this visitation schedule.
Could have disagreed, but that's what he followed.
Ms. Hernandez, just answer the question. Go ahead.
Ultimately, I don't think that's considered disagreeing if that's what he follows, right? Maybe not preferred for him, but that's
I'm gonna object to non-responsive, Your Honor. It's a simple, did he tell you at any point he did not agree to this? Yes or no?
Your Honor, they're creating an issue where none exists. Your Honor, she cooperated with him, and they're saying, while he was cooperating, wasn't he in disagreement? They're manufacturing an issue that doesn't exist. I object to this line of questioning.
Overruled. You're probably right, but that would have to mean that the court would assume that that is in fact the case, and I would rather not assume and just get the answer, get it on the record, whatever it is. Overruled, Ms. Hernandez. Answer the question and let's move on.
Did he disagree at some point? Yes.
Okay. I'll pass the witness, Your Honor.
Cross-examination of your client, Mr. Pena.
Yes, despite that disagreement, did he still go along with the agreement that was described? Are you there, Ms. Hernandez? Can you hear me?
Yes.
Okay. Did you hear the question?
Yes.
Okay. So he told you, I disagree, but what were his actions?
He disagreed, sure, but that's what he followed. That's what ultimately, that's what we agreed to do.
Is that what he did?
Yes.
Physically?
Yes.
And for how long did he do that physically?
Starting since, I think in August, every month up until now.
Okay. And did you agree to these things?
Yes.
And who did the traveling?
Me.
And who paid for the travel?
Me.
Okay. And did you cooperate to the best of your ability during those last 6 months of 2025?
Yes.
And he's now saying that he's now is it your understanding that he's now trying to hold that cooperation against you?
Yes.
Okay, I see. Are you agreeing to follow the visitation order as the judge orders it?
Yes.
Okay. And you understand that when there is a dispute like you all had on New Year's, that you need to follow whatever order the judge makes. Do you understand that?
Yes.
Okay. And what are you asking the court to do with respect to visitation?
I would like to follow standard visitations for 100 miles apart, which is 1 weekend per month. And yeah, that's it.
Okay. And was there anything blocking you legally from leaving to go live with your boyfriend?
No.
Okay. And was there a geographical restriction keeping you in Webb County?
No, I have full geographical rights.
Okay, so as far as you know, you have every right in the world to live your life where you choose. Is that correct?
Correct.
And where do you choose to live your life right now?
In Washington State.
And where in Washington? What city?
Des Moines.
Okay. And do you have a home there?
Yes.
Do you have a bedroom?
Yes.
Do you have your own pillow there?
Yes.
Do you have your own blanket there?
Yes.
Do you have so then they keep on asking you why you have this place in Laredo. Why do you have this? I mean, if you're living in Washington State, why do you have this place in Laredo still?
For the kids, I know that they need to go visit their dad frequently. So it's in everybody's best interest to have that.
So that's an expense that you are carrying
Yeah.
for the benefit of who? Of the kids?
Yes.
Okay. And you're paying for that.
Yes.
And do you feel that they're trying to hold that against you too?
Yes.
Okay. And are you asking that the court order that that all parents be ordered not to speak bad about each other?
Yes.
And are you also asking for the right to get passports for the children?
Correct.
Okay. And you have just filed today. You filed your own motion to modify. Is that correct?
Yes.
Okay. And so, tell me how much you've spent on expenses during the last 6 months to accommodate the father of the child by bringing the child on the airplane and paying for rent at a place here in Ada. How much have you spent altogether, would you say, in the last 6 months of 2025?
Rent alone would be around $6,500, maybe a little bit more. Flight travel and other expenses, maybe like another $6,000.
Okay, and how much has Mr. Maldonado offered to pay for that?
Nothing.
Okay, I see. And then you're also asking that the court order that you all communicate through an app called Our Family Wizard. Is that correct?
Yes.
And you're also making other requests, but I think all those other requests can wait till final hearing. Tell the court where you live and where you plan on living for the foreseeable planned future.
I currently live in Washington and I plan on staying in Washington.
And the residence that you by law have the right to choose for your children, where is that residence?
Washington.
And could please restate the address so that it's clear that that's where you choose as the residence of the children?
Yes, it is 27046 10th Avenue South in Des Moines, Washington.
Okay. So who decides where you live, you or Mr. Maldonado?
Me.
All right. Pass the witness.
That was
Mr. Hernandez, you have your parents still have a home here in Laredo, correct?
Correct.
And you sometimes, when you're here in Laredo, stay at that residence, correct?
No. I visit. Do I
No.
stay there? No.
But you could stay there if you had to spend the night.
I mean, then not really, no. With the kids? No.
Well, by yourself when you're here in Laredo and Mr. Maldonado has the children. Isn't it true you stayed there before?
No.
No. Okay. And your testimony today is that you're maintaining a residence in Laredo to accommodate my client.
The kids.
How does having a residence here accommodate the kids when they're staying, you're bringing them here to Laredo to stay with their father at his residence?
If he works, so there's some days where he'll be like, okay, bring up Friday. If we land on Thursday, it's best for them to have a place that they know as opposed to a hotel or being back and forth who knows where.
And how much are you making in terms of money? Are you getting assistance for all these expenses from your boyfriend?
No.
Okay, so you're paying all this out of pocket.
Yes.
Okay, and how long have you been with this boyfriend?
For a year?
Okay, so you were with him for 6 months before you decided to move with him to Washington State.
Correct.
And he was the reason you chose Washington State, correct?
Well, work and yes.
He works up there as well, correct?
Mhm.
And he just get a job up there?
No, he's worked there.
Okay. And that'd be all, Your Honor.
Anything on
Just
recross?
very quickly, you are asking the court to order standardization for parents who reside 100 miles apart. Is that correct, Ms. Raylene Hernandez?
Yes.
And in fact, that is the present order that is already in effect. Is that correct?
Yes.
So you are just asking the court to follow the order that has existed since October 1st, 2024, correct?
Yes.
The same order that gave you the liberty to move with the children and choose that they live in Washington. Is that the order?
Yes.
Okay. And give me one moment. I think I'm done. One moment, please. That's it. That's all I have. I don't have any more further questions for Ms. Raylene Hernandez, Your Honor.
Let's say this one time. Mr. Maldonado, Ms. Hernandez, Mr. Del Rio, Mr. Peña, does anybody else, any other person would like to put anything else on the record?
I would just like to point out, Judge, that I think there's some misunderstanding. According to Texas Family Code 153.313, for parents who reside more than 100 miles apart, the option is for first, third, and fifth weekend or 1 weekend per month, Judge, at the election of the possessory conservator, which would be Mr. Maldonado.
Your
And so
Honor,
if they're
I'm sorry. I'm sorry for interrupting.
Just to clarify, but I guess I would like to just ask Mr. Maldonado, ask him briefly if the visitation schedule that she articulated was correct, just so we can make sure I would just like to get him to confirm or deny that for purposes of your consideration. If he says, yes, that's what her testimony, that was a visitation schedule that they've been having, then that's all I really would want to elicit at that point.
I'm not following, but Mr. Maldonado, if you understand, you can answer the question. There's no objection.
Yeah, so for the visitation that she ascertained to, can you repeat it?
Well, yeah, it's okay then. Let me ask you this though. Are you still being charged medical support through the Attorney General's office, Mr. Maldonado?
Yes, I am.
Okay, and are you, would you ever make exchanges at her apartment in, I'm sorry, at her parents' house or any other place other than her Laredo house?
Yes, on the court order, I was supposed to surrender the kids to her, so I would surrender the kids at her apartment, and sometimes at her mother's house.
Okay. And if the court were to determine that she is residing in Washington State, are you electing for your first, third, and fifth weekend visits or one weekend per month that you're choosing?
I mean, I would love to have my kids as much as I can. I would love the first, third, and fifth weekends if it could work out. If not, that's the case. I mean, once a month, that'd be more than the time I even see them right now.
Okay. And were you asking for some makeup time, given that she would have them for 2 months and you would have them for 1 month?
Correct. So she would be in Washington for 2 months. She'd come down and I would have them for 1 month. So technically, I guess the days kind of even out. When it came to the holidays, I was supposed to get them on the Thanksgiving that they were dismissed from school, or they don't go to school, but technically that weekend, I didn't get them until the day of Thanksgiving. And so, which is why I wanted to stay with my kids for a while more. And I was supposed to get them on New Year's as well. And I didn't get to. Like, I have all their Christmas presents and all, and I haven't even been able to give it to them.
Okay. And how much are you currently paying child support?
In total, currently paying $1,060 a month.
And when was the last time you met with the Attorney Generals to confirm your child support payment?
This was in October.
Of 2025 or 2024?
2025 October.
Okay, so you last confirmed your...
Yes, before that, I was put on child support on November 2024. And since I had an increase in my salary, we had an update on October 2025.
Okay. I'll pass the witness, Your Honor. Mr. Penny has any questions?
So Mr. Maldonado, you're saying that she would give you access to, that mother would give you access to the child for a month at a time, even after she had left to Washington State. Is that correct?
Yes, after she left to Washington, she would be gone for 2 months. She'd come down, and I would stay with them for the month.
Okay.
And so the next following, it would continue as is.
Well, you know that you had an order in place, right?
Oh yes, these are terms that we agreed on.
No,
Because
hold on.
Go ahead.
That wasn't the question. I asked you, do you know that there's an order in place?
Of course, as it was followed.
And you said you agreed with her. Is that correct?
From the day she said she was going to Washington, we came up with a mutual agreement on the visitation. That would make up the days that I wasn't able to see my kids on the first, third, and fifth weekends.
Well, hold on. But you have you seen your order for more than 100 miles apart?
Yes, I have. Residing, she specifically told me it was a long vacation for her, technically. So that's why we had a
But don't you
visitation that
agree
we
that,
agreed on.
don't you agree though, that a person should get the right to decide where they live?
Absolutely. I mean, when this got signed with the geographical rights, as pertaining to my knowledge,
What geographical?
nobody,
There was no geographical restriction, was there?
or when the court order was signed,
You're upset because she left to go be with her boyfriend, aren't you?
Oh,
That's what all
no,
this is
no, no,
about,
no.
isn't it, Mr. Maldonado?
No, Mr. Pena, by all
Okay, all
means,
right. Well,
I
then,
live my life.
okay.
If I
You
live my
want to
life
visit
and
with the
she
kids
has
3
hers,
times a week, Mr.
and
Maldonado?
the
Mr. Maldonado, you
where
want to
I'm
visit with
coming
the kids
to,
3 times a week?
I would
Is
love
that what
to.
you want?
I would love to
Why haven't you
be with
offered to
them
pay
once a
for
month.
any of the travel? Why
I'm
haven't
gonna
you
start
offered to pay
muting
a penny
folks.
of the
Stop,
travel?
Mr. Pena, just stop. Mr. Maldonado, stop. So, Mr. Maldonado, stop. So here's the thing, folks. Number one, when persons speak at the same time, number one, I can't understand what's being said, so I can't make a decision. And number two, you're going to have an incomplete record. If I make a decision that someone disagrees with, the appellate court isn't going to have a good record because there's talking over each other. So let me ask Mr. Pena to ask a full question, pause and stop. Mr. Maldonado, then you can fully respond. Unless there's an objection, don't interrupt. Mr. Pena, go ahead.
You wanted to visit with your children the first, third, and fifth week of the month, even after my client left to Washington State. Is that correct?
Yes, I would love to. More time with my kids. It's what
No,
matters.
I'm sure you would like that, but how much did you offer to help with the expenses of all of these visits?
I didn't offer to pay anything for the travel expenses, as in, because I believe that she created the distance. And then above that, when I had the kids for the month, I mean, I never complained about me still having to pay child support when they were with me the whole month.
Okay, but but you had them for a month because she agreed to that. Is that correct?
Absolutely, because it would save
And
her.
you agreed to that too. Is that correct?
For the 2 months off and 1 month on? Yeah, I did. She said she was gonna be there she gave me a schedule of when she would be visiting. She gave me a schedule starting from June to December, which was 6
Didn't she
months.
give you more visitation than you were actually entitled to under the order?
I mean, if you think about it, I would stay with them for the month. That's 30 days. For the past 2 months, 3 days each, 3, 6, 9, about a little more than half a month.
She gave you more visitation than you were entitled to. Is that a yes or a no?
Yes, but I would be gone for 2 months with them, so
All
I
right.
mean that's kind
And
of
she paid for all the expenses during those 6 months, correct?
for the travel expense, correct?
Okay. And so going into the future, are you offering to pay any expenses for travel?
At the moment, I don't believe I should be because, like I
Okay,
said,
how
I
often do you
wasn't
want
the
to
one
visit
creating
them?
the distance.
How often do you want to visit them?
As much as I can, whatever we agree on.
Well,
The
we're not
more, the
agreeing. So
better.
I'm wondering, because you want her to come down 3 times a month. Is that what you're asking the court for? Or do you want to
Yes,
put your
but
children on an airplane 3 times a month? Which one do you prefer?
I don't think that would be I think that would put them at a risk, flying, coming and going throughout the month, multiple
So how do you want
times.
to handle that then? What's your proposal?
I would love to see them as much as I can. If I can stay with them for the whole month, I would.
I'm sure you do, but I'm asking you, how do you want to handle the logistics of going and
Your
coming?
Honor, I'm gonna object to that. That's not a decision that we can make, and that's why we're having this hearing. Those are matters that we can make an argument to Your Honor to propose.
He's
whatever
playing
Your
games,
Honor.
Your Honor. He wants to create problems, but
Mr.
not a single
Pena,
solution, Your
Mr.
Honor.
Del Rio. Mr. Maldonado, it's a fair question. possibility. That's what the court rules. So if you have an opinion, you should give it overruled. You may answer.
Absolutely. If I could see them for the first, third, and the fifth weekends of every month, I would love to.
And how are they going to get to, are they going to be dropped off at your house?
I don't believe, since I didn't create the distance, I should be liable to be paying for the travel expenses.
So then you want the mother to pay for the travel expenses, the first, third, and fifth of the month. Is that correct?
Absolutely. And if it's not the
And you
first,
want
third,
your
and fifth,
children,
it's once a month.
and you want your children to travel on a plane 3 times a month. Is that correct? So that they can come visit you?
Like if it's not going to be the 3 times a month, 1 time a month would be good.
Well, hold on. Which is it? I mean, what are you asking for? Because your lawyer says you're asking for 3 times a month. I'm just wondering who's going to pay for it.
Objection, Your Honor. Your Honor, objection. That's improper statement. I mean, we haven't asked for anything yet, Judge.
Sustained rephrase.
So then, you want 3 weekends per month. Is that correct? First, third, and fifth.
I mean, financially, if it wouldn't be beneficial on Mrs. Hernandez's side, we can
What about the children,
definitely
though?
do it once a month.
What about the children? You don't think it's a lot of burden on the children to be going back and forth like that? Would you agree that that's kind of a burden on them?
I mean, I don't see burden in them when I see them physically in person. I know that they missed out on a lot of activities. I was their baseball coach, and
that wasn't my question, Mr. Maldonado.
I don't see burden in them.
My question was, do you think that they should be getting on airplanes 6 times a month?
No.
Okay. And who's going to pay for all of these visits? Are you offering to pay for any of it? I just want to know, yes or no?
No.
Pass the witness.
Anything else, Mr. Del Rio?
Just briefly, since Mr. Bennett asked you about what your request is, would you prefer to have the children for 1 month on and then allow them to return to mother for 1 month and repeat that process until we have final orders?
Absolutely.
Do you feel that visitation schedule would be less expensive for Ms. Hernandez to pay and less taxing on the children in terms of flight time?
I believe, absolutely.
Okay, no further questions, Your Honor.
I need to follow up real quickly. Are you asking for custody of the children? Are you asking to designate where they live?
Designating where they live with their mother. I'm not asking for that. I'm asking for my visitation.
But you want to send them back and forth between you and mother, like a ping pong? Is that what you're talking about?
Objection, Your Honor. That's argumentative, Judge. Your Honor, he's arguing with the witness.
Sustained.
Pass the witness.
No further questions.
All right.
I don't have any witnesses, Your Honor. Maybe a bit of argument. It's Mr. Del Rio's motion, though, I think.
Well, just I think we've covered the witnesses.
Anything to
Thank
close?
you, Judge. If I may proceed, Your Honor? Or?
You've got 2 minutes. Go ahead.
Thank you, Judge. So with regards to the residents, Your Honor, I don't think that the focus of that from the court should be the intent of the individual. I don't think she has any intent to stay there permanently, Judge. She still maintains a residence in Laredo that she's paying monthly for, which she could have terminated that lease months ago, 6 months ago to be exact. The idea of keeping that home and that expense for the benefit of the children just is illogical. It makes no sense since she admitted that she visits the parents. They have a home there. And my client testified that he's picked up the children from that home. As far as her testimony regarding the home in Washington, I believe she says it expires soon. We don't know if she's going to renew it. She told my client and admitted that she did at some point plan to move back to Texas and to San Antonio specifically. She hasn't registered to vote in that state. She still has, I don't think she said she had a license to that effect. I think it's prudent that she went ahead and got state health insurance. I do think that's smart, but I don't think that's dispositive of her establishing residence in Washington. Now, with regards to the visitation, Judge, I think we should keep something similar to what the parties had agreed to prior to the filing the suit. She created the distance. Texas law and standard courts practice the understanding that if you create the distance, you can't ask the other party to make up financially for that cost. She's gonna have to bear that, Judge, and we are asking that we bear that. But that in mind, because it is a long distance, I think the better thing for the children temporarily would to be 1 month on, 1 month off. This is something that it would be really untenable to do first, third, and fifth. I think we can all agree to that, despite what Mr. Benya was, trying to elicit from my client. I think that's obvious, and I just
2 minutes have expired. Last word. Anything else?
just, Your Honor, that we do go with the schedule of 1 month on, 1 month off, and that my client not be responsible for additional expenses of travel.
2 minutes, Mr. Peña. Go ahead.
First of all, it's kind of offensive to be told by the father of your child where you live. I think that that's kind of the height of arrogance. And then the other, it just doesn't feel very nice being told, oh no, I'll tell you where you live. And then the other thing, Your Honor, is that even if Mr. Del Rio's argument was 100% correct, and she didn't prove, which she did, that she has established residence in Washington, it doesn't matter because physically we're still dealing with the same logistical problems. So this whole idea of, well, she doesn't really live there, that's a fraud. That argument really, when you follow it out to its logical conclusion, goes nowhere because it still doesn't solve the best interest of the child, which is how are we going to get them from point A to point B in the meantime. I think that my client is being criticized and punished for going out of her way to cooperate and give Mr. Maldonado much more visitation that he was entitled to, and she voluntarily paid for a lot of it herself. So we're asking the court to take that into consideration. That's all I've got.
Just reviewing some of your testimony, Mr. Maldonado, Mr. Hernandez. I was trying to remind myself to remember the timeline. All right. File number 2024 FLI 1859C3. The court at this time finds that it has continuing exclusive jurisdiction over the subject of this case, these two children. So in order for the court to make any decisions or orders, and these are just temporary, they're not meant to be final. I'm going to give you a final hearing date right now. You're both to come to court on March 31st at 2 p.m. Based on the evidence and testimony you present on that day, things are going to change, very likely to change. But these are the temporary orders that you'll be working under between now and then. So the question that the court first needs to answer is the question on residency. And the only thing that the court has that to use as a guiding principle, as it were, when a person, a parent in this situation, moves to another location, another jurisdiction, the more common occurrence that happens in Webb County, much more common than something like this, is seasonal migrant work, and the court is much more familiar with those type of situations. And in those type of situations, if somebody moves to another jurisdiction, it's just meant to be seasonal or temporary. That's not what's going on in this case, although there's some parallels and similarities. The question is then, where does Ms. Hernandez reside? The facts and testimony presented to the court today is that this court has continuing exclusive jurisdiction, one. Two, the residences, all the places that Ms. Hernandez lives, the longest standing one is in Laredo. The Washington move is more recent, but what was instructive to the court is that there is a situation that's very likely to happen at some point, who knows when, in the near future, for Ms. Hernandez to move to San Antonio, meaning the court can infer and now find that the move to Washington isn't meant to be permanent. Rather, the permanent residence is in Laredo. So these are the temporary orders based on that. And before I give the ruling, Ms. Hernandez, I need to let you know that this court, nor any court, can determine where you live. You have rights and duties, civil rights, and you can live wherever you want. The thing is that the court does have the authority to determine the possession schedule of your children, which is something totally different. This court doesn't want to place a burden on either or both parents between now and March the 31st. So this is what the court is going to order. There's 7 weekends between now and the date of the final hearing. Based on what's happened, there should be, 1 second, let me just take judicial notice, an actual notice of the calendar before I. There are 7 weekends between now and spring break. All right. Between now and spring break, Mr. Maldonado, you will have the right to visit with your children once over a 4-long-day weekend. You can choose those dates, 4 days, and it could be either Friday to Monday or Thursday through Sunday. You can choose the weekend, the long weekend, and you can choose the airport. And there's a chance that Laredo is the best situated place. The largest airport closest to Laredo is San Antonio. If you choose San Antonio, then you're responsible for driving to San Antonio and then picking them up there. You're responsible for the flights. And Ms. Hernandez, you need to be on those flights. Then you'll begin a longer period of possession from March the 9th. And by the way, these children, I know flights, these children should not be flying before 8 a.m. So if there's a 6 a.m. or 5 a.m. flight, don't choose that for these kids. Do something after 8, preferably before 9 p.m. too. Then you'll begin a longer period of visitation on March the 9th. And you're responsible for those flights, Ms. Hernandez. And you also have the choice of flying to Laredo or flying to San Antonio. If you fly to San Antonio and you choose that, then everybody's responsible for their own travel from Laredo to San Antonio. And then the kids will be here in Laredo on March the 31st when the court holds its final hearing. One more point of to note for the court, that if it were in fact the case, as one more point of consideration for the court, and that's why I was trying to review my notes to get a hold of the timeline. There is a chance, and specific dates weren't mentioned. I have just general months, but there is a chance that if in fact Ms. Hernandez resided in another jurisdiction, then a motion to transfer would have been filed. It wasn't, so I have to presume and assume that it is the court of continuing jurisdiction. So for all of these reasons, I find that the residence is here until further evidence, testimony, and orders for the court. All right, we'll come back on March the 31st at 2 p.m. Mr. Maldonado, that was a lot to digest. Do you have any questions?
No, Your Honor.
Mr. Hernandez, a lot to think about. Any questions for the court?
No. The only thing is that I think he stated that the kids have been with him for a whole month at a time. It's been about, I believe, 2 to 3 weeks at most. And at the end of those 3 weeks, our youngest daughter, she's 2 years old. She seems to be very different, you know, she like attachment issues to me. And I just think that a child that young shouldn't go, you know, away for that from a parent.
So I recall that was the testimony, which is why this court did not do 4 weeks. This court did 3 weeks, which is consistent to the pattern of behavior that both you and Mr. Maldonado have agreed to in any event. I didn't do more than what you were already doing.
Okay.
All right.
For some reason, I thought you said 30 or 31. Okay.
March 31st is when you'll come back. But
Okay.
from the 9th to the 31st, that gives the 3 weeks that you had been accustomed to in any event.
Okay.
And in any event, both you and Mr. Maldonado will have daily video conferencing abilities with both of your children at 7 p.m. or the very next available time. And I don't mean 7 p.m. or then 7 a.m. the next day, or 7 p.m. or 7:05 for an amount of time that is reasonable. Children that age have smaller attention spans than others, so keep that in mind. A lot to contemplate. Mr. Del Rio, thoughts, comments, or objections? Go ahead.
If I could just get that order stated one more time, Judge. I was a little confused at how you wanted it to play out, Judge. I think if you could state it one more time so that we don't have any issues when we're drafting the order.
So between now and March the 9th, there's to be one long weekend, 4 days. It's Mr. Maldonado's election of the weekend. Ms. Hernandez will be responsible. Excuse me. No, Mr. Maldonado's, he's making the choice, and he's going to have to look for flights and all these things. But Ms. Hernandez really needs to be on that flight. So ostensibly Friday through Monday or Thursday through Sunday or any other dates that are agreeable. And I'm assuming that it's not scheduled, but it's airline prices that may weigh in on the parties. But a 4-day long weekend, and then they'll go back.
And who would pay? Who pays that flight? And for the children, or
also for the mother? That's the question.
What did the court say? The court said that it's Mr. Maldonado's election, so he needs to pay. But then coming back on the 9th, it's Ms. Hernandez. And that's only one flight.
And he's paying for, I guess I wanted to clarify, he's paying only for the flight of the children, or he has to pay for mother as well?
No, only for the children.
Okay, so father. And then going back, she pays for the return trip.
No, it's his election, and he gets to he has to put that full bill for that one extended weekend.
Okay, for the children. Okay, and then it reverses when it's her period of time. She elects, she pays.
But she's not electing. I'm saying it should be the start of spring break, March the 9th. All she has to do is deliver them to Mr. Maldonado, either in San Antonio or Laredo, whatever airport and flights are most available. And then they're coming back on March 31st for their final hearing. So then the court will make additional orders at that time.
Okay.
Residency
So for
here in
question?
Laredo. Yes, sir.
Sorry, Your Honor. I didn't mean to interrupt you, Your Honor. I'm sorry. Question. Who, and it sounds like a silly question, I realize that, but between March 9th and March 31st, the day of the next hearing, who are you envisioning has the children?
Mr. Maldonado.
Got it. Okay, understood. I just didn't understand that one part.
That was,
Right,
that
I
was
was
exactly
confused.
Ms. Hernandez's question. She did not want more than 3 weeks. That is exactly 3 weeks. So, all right.
Got it.
Next.
Understood. That's clear now. We can, I think the rest of it can be argued at the final hearing.
All right. Anything
Okay.
else from any person? All right.
I just, okay, so just that Mr. Peña threw me off. So, my client will elect one weekend between now and March 9th, for a 4-day weekend. He will pay for the children's flights going and returning. So he'll elect the airport, and then when they'll come back to Laredo on March 9th.
That is Ms. Hernandez's portion.
Okay, okay. And then they'll stay
Ms.
here
Mr.
in
Maldonado
Laredo
is
until,
responsible for 2 flights. She is responsible for 1.
okay, so when she'll fly them down, and then they'll stay till the 31st, and that's when they'll be with my client from March 9th to the 31st.
Correct. And she'll fly them down
Okay.
to the airport of her
Of her
election.
choosing.
And I'm just saying airport, but y'all can fly. I mean, y'all can drive. I mean, there's that, but just it's still 4 days.
Yeah, okay.
All right.
Okay, all right, Judge, thank you.
Anything else from any person? All right, Mr. Maldonado. Ms. Hernandez.
No, Your Honor, nothing further.
Mr. Maldonado, Ms. Hernandez, I wish you both well. More importantly, I wish your children all the best. We'll see you very soon. Good luck to all.
Thank you.
Mr. Del
Thank you,
Rio,
Judge.
Mr. Peña, it's always good to see you. Have a great 2026.
Thank you, Judge, you too.
Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor.
This now concludes this docket held in person and by video conference at Webb County Court at Law 2 for Thursday, January 15, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. The court wishes everyone well. Have a good day.